Court is now in session. Please be seated.
Good morning. Bonjour. This is a reference by the Lieutenant Governor and Counsel pursuant to Section 8 of the Courts of Justice Act, referring to this court the following question. Is the Greenhouse Gas Pollution Pricing Act, Part 5 of the Budget Implementation Act 2018, unconstitutional in whole or in part? I will begin by introducing counsel on behalf of the parties and the interveners, and ask that when your name is called, you stand and acknowledge your presence. On behalf of the Attorney General of Ontario, Josh Hunter, Patrick Ryan, Thomas Lipton. On behalf of the Attorney General of Canada, Charlene Tellis-Langdon, Christine Moore, Mary Matthews, Neil Goodrich. On behalf of the Attorney General of New Brunswick, William Gould. On behalf of the Attorney General of British Columbia, Gareth Morley. On behalf of the Attorney General of Saskatchewan, Mitch McAdam and Alan Jacobson. On behalf of the Assembly of First Nations, Stuart Woodkey, Adam Williamson. On behalf of the Athabasca Chipewyan First Nation, Amir Ataran. On behalf of Canada's Eco-Fiscal Commission, Stuart Elgee. On behalf of the Canadian Environmental Law Association, Environmental Defence, and Sisters of Providence of St. Vincent de Paul, Joseph Castrelli and Richard Lindgren. On behalf of the Canadian Public Health Association, Jennifer King, Michael Finley, and Leanne Langstaff. On behalf of the Canadian Taxpayers Federation, Bruce Halser, Christine Van Gin, and Aaron Woodrick. On behalf of Centre Québécois du droit de l'environnement et équiterre, David Robitaille. On behalf of the David Suzuki Foundation, Randy Christensen, Joshua Ginsberg. On behalf of the Intergenerational Climate Coalition, Nathan Hume. On behalf of the International Emissions Trading Association, Lisa DeMarco, Jonathan McGilvery. On behalf of the United Chiefs and Councils of Mindu Minising, Cynthia Westaway, and Natalie Chalafour. On behalf of the United Conservative Association, Ryan Martin. Thank you. Just let me mention two brief business matters. First, for the convenience of all concerned, the hours of sitting will be as follows. We'll begin court at 10 o'clock sharp each day. We'll take a 20-minute morning break at approximately 11:30. We'll break for lunch at 1 p.m. We'll resume in the afternoon at 2:30 p.m. and we'll continue to 4 p.m. approximately. We may amend these hours slightly so that our breaks don't interrupt the orderly flow of submissions, but we'll aim for those times. The second point, which you all know, is that you've been assigned time limits. Your times for the parties include reply. We'll ask that in fairness to all concerned that you stick to those time limits and monitor yourselves. We don't have a clock other than the big clock on the wall. And we'll now call on counsel for the Attorney General of Ontario.
Thank you, Chief Justice. For my submissions this morning, the court will need a copy of our Buff Compendium and our white primary factum. Also, I've handed up, just hot off the presses, a copy of Bill C-97 that was introduced in Parliament last week, which you should also have with you. So Ontario appears today to argue that the Greenhouse Gas Pollution Pricing Act, which I will refer to as the Act throughout my submissions, is ultra-vires parliament. It is not supported by any of the heads of power set out in the Constitution Act 1867, and it is also, to the degree it imposes taxes or regulatory charges, offside of Section 53 of the Constitution Act 1867. This morning, I will be providing an overview of the Act and discussing its operation, providing an overview of the measures Ontario has and is taking to combat climate change, discussing some of the interpretive principles that various parties have put forward to shape this court's consideration of the federalism issues, and then discussing why in our submission the Act cannot be supported under the National Concern Branch of the Peace, Order, and Good Government Power, or POG. My colleague, Mr. Ryan, will then be dealing with why the Act cannot be supported under Parliament's taxation power, and why the charges it imposes contravene Section 53. Although I'm happy to answer questions on it, I propose to deal with any other heads of power that are raised by interveners in the course of our reply on Thursday. Before I begin going through an overview of the Act and what it does, I just want to take a moment to make it clear what in our submission this reference is not about. This is not a reference about whether climate change is real. It is. This is not a reference about whether greenhouse gases produced by human activity are contributing to climate change. They are. And it is not a reference about whether action needs to be taken. Action does need to be taken. Ontario has taken action, and Ontario is continuing to take action. What this reference is about is whether Parliament can impose its solution to the problem on the provinces, or whether in a federal country the provinces have the flexibility under our Constitution to choose what best meets their local circumstances as they work together to combat climate change. With that background, I'd like to turn to the Act that's at question on this reference. I'll start briefly just by referring to tab 1 of our compendium, which is the overall Act that was introduced in 2018. The Budget Implementation Act 2018, number 1. I'll come back to number 2 later. And as you can see, just on the second page of that tab, tab 1, this was an act that had a number of parts. And as is common in budget legislation, it amended a number of taxing statutes. The Income Tax Act, the Excise Tax Act 2001, made some changes for Canadian Forces members, and then, as Part 5, introduced the Act. Now the Act, just because of its size, we didn't reprint it in the compendium, but it can be found at tab B2 of our factum. I'd just like to take the court through, it's a very dense act, but let's take the court through a number of the more salient provisions, just so we understand what exactly this act does, and that will, of course, be relevant when we try and characterize it in the division of powers analysis. The Act starts off, and it says this is a B2. I'm starting on page 1 and 2 of the Act, its preamble. And it sets out a number of agreements, international agreements that Canada's agreed to. I'll be coming back to that later, why I say those international agreements are relevant from a policy basis, but are not relevant to the constitutionality of the Act. It refers to Parliament's views that carbon taxation is the best means to combat climate change. And again, I'll be coming back to why that's a policy question, but it's not a legal question. And it notes, and this will be relevant later as well, that the pricing of greenhouse gas emissions on a basis that increases over time. So baked into this act is these prices have to keep going up. There has to be more and more taxes on Canadians over time. So what does the act actually do? It has two main parts that we are saying are unconstitutional, parts 1 and 2, and then two parts that are subsidiary, which we do not take issue with, parts 3 and 4. Part 1, which starts on page 3, imposes a fuel charge. Now, what is a fuel? The definition of fuel is found in section 3 on page 8. And so, fuel means a substance, material, or thing set out in column 2 of any table in schedule 2, other than certain exceptions, or a prescribed substance, material, or thing. So this definition basically means a fuel is whatever the governor and council says a fuel is. The other important definition for part 1 is over the page on page 10. A listed province means a province or area listed in part 1 of schedule 1. And so again, where does this act apply? Wherever the governor and council says so. So what does it actually do when it applies? So I'd ask you to turn to section 17, which is on page 21. So section 17.1 says, subject to this part, a particular registered distributor, and so for example, Union Gas or Esso, people who distribute fuels, in respect of a type of fuel that delivers at a particular time, fuel of that type, in a listed province to another person, must pay to Her Majesty and Right of Canada a charge in respect of the fuel in the listed province in the amount determined under section 40. The charge becomes payable at the particular time. Now, if you go on through 18, 20, 35, there's lots of other similar charges if you're importing it, if you're selling it. The idea basically being is that if you're bringing a listed fuel into Canada, selling in a listed province, you're going to be paying these charges. If you turn to section 40, which is on page 48, we see how the charge is calculated. So section 40 sub 1 says the amount of a charge payable under this division, other than section 38, which is one of the particular subtypes of the charge, in respect of fuel in a listed province is equal to the formula A times B. So A, again, there's some exceptions, but C is the general case. In any other case, the quantity of the fuel in respect of which the charge becomes payable. So if we're talking about gasoline, it's liters. Talking about natural gas, it's cubic meters, and so on. B, again, there's a special case in A, but the general case in B, the rate in respect of fuel of that type for the listed province applicable at the time the charge becomes payable. So it's basically you pay a charge of X cents per liter or cubic meter of fuel. And I'll come to, when we get to them, they're in the schedules, what those actual amounts look like. The last thing I'll note in part 1, and this will become relevant in reply to some of the intervener submissions, there's no prohibition on owning, buying, distributing, doing anything with fuel. You can buy as much fuel as you want, as long as you pay for it. There are some offenses in the Act, and that's set out in subdivision J, starting on page 125. But they're all administrative offenses. Not filing a return, not providing information to the Canada Revenue Agency, lying to the Canada Revenue Agency, and so on and so forth. They're not at all about the actual activity which the federal government claims to regulate, the production and consumption of greenhouse gases. So what then does the federal government have to do with the money it raises under Part 1? That's set out on page 161, section 165. And so, first of all, they define net amount, which is essentially the amount collected in an area or province, subject to any refunds or whatnot Her Majesty has to make. And then sub 2 says, for each province or area that is or was a listed province, the minister must distribute the net amount for a period fixed by the minister, if positive, in respect to the province or area. And the minister has choices. They can give that money to the provinces. They can give that money to prescribed persons, persons of a prescribed class, persons meeting prescribed conditions, or any combination thereof. And I'll come back to that in a few minutes. We'll talk about what the federal government has actually decided to do under that section. If you turn over the page, the last section, part 1, I'd like to take the court's attention to is we've talked about these fuels and listed charges that are set in the schedules. Well, how do we decide what's in the schedules? Did Parliament set them all out ab initio? No. The Governor and Council is given a broad regulation-making power, and it goes on for about 5 pages, all the things the Governor and Council can make regulations about. But the key point, in the middle of page 163, sections 166, 2 to 4, for the purpose of ensuring that the pricing of greenhouse gas emissions is applied broadly in Canada at levels that the Governor and Council considers appropriate, or as I'll characterize it when we come to the division of powers analysis, for the purpose of ensuring the provinces do things the way the federal government wants to do it. The Governor and Council may, by regulation, amend Part 1 of Schedule 1 by adding, deleting, varying, or replacing any item or table, and, sub 3, shall take into account as the primary factor the stringency of provincial pricing mechanisms for greenhouse gas emissions. Notice it doesn't say the stringency of provincial plans reducing greenhouse gas emissions. Only pricing counts. Not price related. Even if it's completely effective, it does not count. And similarly, Schedule 2 can also be amended by regulation under sub. So that's part 1, the fuel charge. There's a second part, the output-based pricing system on industrial greenhouse gas emissions, is set out in part 2. Now again, I'd like to start with the definitions, which start on page 167, section 169. Here, the 2 key definitions are a covered facility. That's the facilities to which this regime applies. And means a facility, including a platform at sea, that's located in a province or area set out in part 2 of Schedule 1. So again, there's this listed province concept. And either meets the criteria set out in the regulations for that province or area. I'll take the court to the regulations in a few minutes. Or there's also a opt-in is designated by the minister under subsection 172, sub 1. The other key definition is greenhouse gas. The substances to which this scheme applies means a gas that is set out at column 1 of Schedule 3. So it's a little bit more defined than fuel. It does at least have to be a gas. But again, it's very open-ended definition. So what does this regime require? If you turn over the page to page 168, section 171, sub 1, there's a requirement that a person responsible for a covered facility must apply to the minister, that's the federal minister of the environment, for registration of that covered facility. It must include information and so on. There's also a power under 172, if you are not required to be a covered facility, you can ask the minister to so designate you. Turning over the page, section 173 on page 170. Each compliance period, which is basically a year, a person responsible for a covered facility must, in accordance with the regulation, submit a verified report to the minister showing how much greenhouse gases they emitted with respect to the limit that applies to that facility. And then what happens if they go over their limit? That's section 174. They have to provide compensation for the excess emissions there's a deadline. If they pay it by the deadline, they pay one rate. If they don't pay it by the deadline, it goes up under four times the rate as a late penalty. And so that compensation can be provided either through compliance units. So there's units you can get from the minister because you're under, or you can purchase from other people, or an excess emissions charge payment, which again is set out a rate. And that rate is set out, as sub 3 points out, it's one compliance unit for each ton of carbon dioxide or equivalent other greenhouse gases, or the excess emission charge set out in column 2 of Schedule 4. Another one of these schedules listing the rates. If you turn to page 175, section 188, down at the bottom. Again, the minister is required to distribute the revenues from each province or area. Again, they can go to the province directly. They can go to persons set on the regulations or meet criteria set on the regulations, or a combination of both. Over the page, on pages 176 and 77, sections 190 and 191 again give the governor and council broad power to set out the greenhouse gases that are listed in the schedules, to determine basically how they map onto carbon dioxide, what the multiplier is for different gases, list provinces, and set the rates. Similarly, like Part 1, there is no prohibition on emitting greenhouse gases in any amount you please, so long as you either get compliance units or pay the charge. There are again, setting out, these are on pages 195 and following, a number of offenses, starting at section 232. Again, they're all the administration offenses, not complying, not filing, not providing information, lying, etc. Not emitting greenhouse gases. No prohibition on that anywhere in the Act. So that's Part 2. So it's Parts 1 and Part 2 that Ontario says are ultra vires Parliament. I will, for completeness, just quickly take the court to Parts 3 and 4, which we are not challenging. Part 3 starts on page 210. And what Part 3 does is allows the governor and council, by regulation, to provide that provincial laws apply to federal works and undertakings, areas outside of province, Indigenous lands, federal crown lands. So all matters that are clearly within Parliament's enumerated powers, which is why we're not challenging that aspect of the Act. And the last part, Part 4, which is just on the bottom of page 213, requires the Minister of Environment to report to Parliament. And of course, Parliament can require federal ministers to report to it on any matter it sees fit, so we don't challenge that section. Finally, in the Act are the schedules, which is in many ways where the meat of the Act is. We have in the factum, we have the versions as they stood in November. For completeness, we've put in at tab 2 of our compendium the order that was just made March 26th, amending those. So that's actually the most up-to-date version of the schedules are in our compendia. And the key points, it's really for Ontario's point of view, not much has changed. It's more some of the other provinces and territories, but the key points are Ontario is listed for both parts as a listed province. There are a range of prices set out for each province and each fuel for Part 1. Most noticeably for gasoline, just an example, it's 4.42 cents per liter for 2019-20, going up year after year, 6.63 cents next year, 8.84 cents the year after that, and 11.5 cents after March 31st, 2022. Similarly, for Part 2 of the Act, Schedule 3 lists a number of greenhouse gases that Parliament has prescribed. And they have what's called a global warming potential. That's basically just an equivalency. So because some have more of an impact than others. So for example, carbon dioxide would be 1, and everything else it's trying to put it as an equivalent amount of carbon dioxide for simplicity. And finally, Schedule 4 sets out the excess emissions charge that industrial emitters have to pay if they don't have enough compliance units. And that's just on page 224 of the Act. That starts, again, 2018. It was $10 per ton of carbon dioxide equivalent, and it goes up year after year until it hits $50 per ton as of 2022 and further. And of course, the Governor and Council can change those rates further if it sees fit to do so. The next tab in our factum, tab 3, just for reference, sets out, we talked about covered facilities and the power to decide what a covered facility is by regulation. This is the regulations that do so. And basically, there's a long list of 36 different industrial activities in Section 3 that if you're doing those and you emit more than 50 kilotons or more of carbon dioxide equivalent, you're a covered facility and you have to register. You can register if you do less, but you have to if you're in one of these industries and emitting more than this amount of carbon dioxide. And then just finishing off the regulations, we've also included in our factum the very, very detailed information that all these facilities have to produce to the federal minister. That was a draft version. I believe they now have been enacted. So that's, in a nutshell, the Federal Act. And from now on, I'll just be referring to my compendium. So what is the federal government doing with these powers that Parliament has granted it? So first of all, at tab 3 of the compendium, they released last fall the fuel charge rates that came into force as of April 1st. And I've already taken it, they're actually set out in the schedules as amended by the regulations that were passed a couple weeks ago. But for convenience, the backgrounder sets them out in a slightly more readable format for your convenience of all the different fuels and how they're going up year after year.
Are the prices the same for every province?
I believe so. I'm just going to double check.
The 4 cents for Ontario.
They're less in the territories for some of them, but generally the prices are the same for the different provinces.
4% allocation for 2019-20 is for all the provinces.
Yes. I'm going to confirm that, but I believe that to be the case. Yes. Yep, at least for the first 3 years. I didn't check the fourth. So that's the fuel charge, setting it out. And then what are they doing to give the money back? Well, there, the Budget Implementation Act 2018 number 2, which can be found at tab 25. Sorry, 25 is the backgrounder, setting out how they'll be doing it. 26 is the act itself. They've created a refundable tax credit, which my colleague will talk about in more detail because it's more relevant to the Section 53 analysis. That's basically a straight per capita amount based only really on where you reside. It's not based on what measures you've taken to combat climate change. It doesn't have to be used to combat climate change. In fact, you could use it to buy a Hummer or whatever you want to spend it on. The other thing they're doing is they're giving targeted grants to municipalities, universities, schools, etc. The authority for that was just set out in the Budget Implementation Act 2019, which I handed up this morning. So if passed, they'll provide express authority. The Act also provides authority, but I think they're allowing some internal differences as to which ministers can authorize these payments. They don't have to necessarily go to the Minister of Finance for every check they're writing. The other point I should make is that what I've just talked about, these climate change initiatives and the funding to schools or hospitals or municipalities or Indigenous groups or whoever the federal government wants to write checks to, that only applies in listed provinces. In provinces that have agreed to have a carbon charge, some of the provinces, some of the territories, for example, have asked the federal government to impose this, they get the checks directly. Or any funds that are collected because of, it's collected in another province because they're being transported into Ontario, for example, those would again go back to those provinces. So basically the governor and council has said, if you agree with our scheme, you do things the way we want you to do it, we'll write you a check. But if you're on the naughty list, we're going to give the money to someone else so you can't, perhaps remediate the cost to your taxpayers from this tax coming into force in your province. So that's the Federal Act. I'd also like to just take a few minutes to provide some context as to what Ontario is doing in regards to climate change. Now, I'm only going to...
Mr. Hunter, just before you turn to that,
Yes.
I just want to try to visualize the money coming back to ordinary citizens of Ontario. Tell me who's going to get a check for how much?
So the most convenient way to do that, Justice McPherson, is the backgrounder at tab 25. They actually set out what the federal projections of that are. And the proceeds and proceeds returned for Ontario are at the top of page 2 of that backgrounder. So this is in millions. So the projection is this fiscal year, they expect to collect about $1.7 billion from Ontarians, going up to almost $4.3 billion in 2023-24. There's some collection and target credits, so the net proceeds are a little bit less. The vast majority of that, $1.5 billion in 2019-20, going up to $3.8 billion, are going back as these climate action incentive payments, which is a fancy name for what's essentially a refundable credit on your income tax return.
And does everybody get the same?
Everybody gets that. There is a slight difference in the amount, depending on whether you're in an urban area or a rural area, and also how many people are in your household. Like most tax credits, it's based on standard tax measures, but it goes to everyone. It's a straight per capita, based solely, the only difference is residence and family status, and the amount you get. And then there's some small amounts, as I say, 105 million going up to 255 million for small and medium enterprises, 50 million going up to 125 million for various nonprofit and broader public sector entities. The federal government hasn't released the details of how those amounts are going out, but the vast amount of the fuel charge is supposed to go out via the climate action incentive payments. Similarly, they haven't yet given the details on how the emissions trading compliance charges will be given out. They've said they're going to do it in some way that helps industries with this, but we just don't know the details yet.
So both the taking of the tax at the front end through the gas stations mainly, and the disbursement of the revenue from that, at least 90% of it, back to ordinary citizens. Are both of those components identical in all 10 provinces? So there's no different treatment of them. They're identical, and the only difference, therefore, between Ontario and Saskatchewan and New Brunswick on one side, and BC and Nova Scotia and Quebec on the other side is those other 3 provinces are content with this. They don't have a problem with it, whereas Ontario and the other 2 think it's unconstitutional.
Well, no, because the Act only applies, as I read through those charges, the charges are only imposed if you're in a listed province or area. And the only provinces that the governor and council has listed under either Part 1 or Part 2 are those it disagrees with the means they've chosen to combat climate change.
Right.
So you're not paying anything in the other provinces to the federal government.
Because they're in compliance. They agree.
Because the federal government has decided that the means they're addressing climate change are done the way the federal government likes it.
Right.
Even though the other provinces may be doing it another equally effective way that's just not a price on carbon.
Okay.
And the federal government has chosen to treat those provinces equally. It doesn't have to do so under the Act. On the current point, the rates are currently the same. What is different is how it's going back. The amounts that are given back under the credit, the amount you get, does vary province to province because it's based on the amount of revenues collected in that province. And then the Minister of Finance has a power under the now section of the Income Tax Act to set the amount. And so, for example, people in Saskatchewan are getting a larger credit than people in Ontario. But everyone in Ontario is treated the same.
So do I understand that Canada has made a determination that in the provinces other than the listed provinces, the provisions are sufficiently stringent that they are prepared to accept those provisions?
That they have chosen to tax carbon in a sufficiently stringent manner, yes.
Including whatever fuel charges they make and their participation in a...
Whatever pricing mechanism they've chosen to impose. But the key point is it must be a pricing mechanism. No other mechanisms can. And so, for example, as I'm about to get into, closing down all the coal-fired plants in Ontario, which does have a cost to people on your hydro bills, and even though that's reduced Ontario's carbon emissions by 22%, that counts for nothing in the federal calculus.
Was there an indication in the materials if coal plants have been shut down in the other provinces as well?
I'm not aware if they are. I will say that the federal government is going to be using its criminal law powers to gradually require that, and that's not something we're challenging. I mean, that it's an actual prohibition of an activity, not trying to put a price on it. So that is criminal law, whereas this is not. And those regulations are in the materials. But no, Ontario is further ahead than all the other provinces. But we just don't get any credit for that. So actually, on that note, that's actually a good segue into tab 4 of the compendium. And this is Canada's own evidence. There are Dr. Dominique Blaine about the greenhouse gas emissions by province. And there's a chart at the top of paragraph 21 on the second page of the tab, page 963 of Canada's record, that shows the greenhouse gas emissions. And you'll notice, if you go down to Ontario, from 2000, the very last column is the change from 2005 to 2016. And that change is important because, of course, the Paris Accord commitments are based on reductions over the 2005 baseline. And we've committed, and Ontario has reaffirmed its commitment, as I'll take you to in a minute, to achieving that 30% reduction by 2030. And as you can see, Ontario is already the furthest ahead, minus 22%. Whereas other provinces, I think only New Brunswick has a slightly higher at 24. The rest are all smaller reductions or even increases since 2005. And Dr. Blaine goes on at paragraphs 24 and 25 to point out that most of those reductions came because we closed 19 coal-fired generating units. But none of those reductions, even though they're just as effective at reducing climate change as any other mechanism, none of those count to determining whether Ontario has a stringent plan. So turning to what Ontario is doing to combat climate change, I'll start with the Cap and Trade Cancellation Act 2018, which is at tab 5. The current government promised in the last election that it was going to repeal the previous government's cap and trade tax. It was said it was a cost that was too much for Ontarians. And it did that. Passed the Cap and Trade Cancellation Act. But that's not the end of the story. It wasn't just we're getting rid of cap and trade, we're not going to do anything else. It said, no, we do need to take action. We need to take action that meets the needs of Ontario, meets the circumstances of Ontario. And that's set out, as the statutory requirements to do so are set out as sections 3 to 5 of the Act on page 2. It requires the Government of Ontario to establish targets for the reduction of greenhouse gas emissions in Ontario, make them available to the public, requires the Minister of Environment, Conservation and Parks, with the approval of the Lieutenant Governor and Council, to prepare a climate change plan, can appoint advisory panels, must give public notice of that plan, and on a regular basis, prepare reports. Turning to the next tab, tab 6, the Minister of the Environment, Conservation and Parks has complied with that statutory requirement.
I'm sorry, I didn't,
Tab 6,
yes.
the Made in Ontario Environment Plan, is the Minister has complied with those statutory requirements. This plan was released on the Environmental Registry for public consultation. There are thousands of consultation responses. They're currently being considered by the Ministry, and a final plan will be released in due course. That environment plan contains, we're not just dealing with climate change. Of course, Ontario's government wants to promote its clean environment in a wide variety of ways. But the climate change section of that is set out in this excerpt. The whole plan is in the record for the court's reference. Key point on page 21. After saying out a number of other matters we're taking, Ontario recommits to achieving the Paris Agreement targets. It's in bold on the right-hand column. Ontario will reduce its emissions by 30% below 2005 levels by 2030, which aligns Ontario with Canada's 2030 target under the Paris Agreement. And that is the statutory target required by the Act. And then it goes on to discuss the wide variety of measures Ontario will be taking to do that. What they're not doing is putting a tax on everyday Ontarians every time they drive to work, heat their homes, take their kids to school, take their kids to the hockey game, enjoy this beautiful province. That's not happening because that is too much of a burden to put on Ontario taxpayers.
But how is it a burden if 90% of that money immediately gets returned to the very same people who just paid it?
That's the point. It doesn't go back to the same people who just paid it. It goes back to everybody,
Right.
whether they did anything to combat climate change or not. So what it does is those who, the realities of this province, there are long distances, there are cold winters, people need to drive, people need to heat their homes. Everyone needs to do that. But no matter how much you do that, you're a long distance trucker who has to do that for your business. You're a person living in rural Northern Ontario who has to commute long distances and has to buy natural gas to heat your home. You are going to pay far more of that charge, but you'll still just get back the same per capita amount as someone who lives in a urban center where there's lots of alternatives you can walk to work. So that is the point. Now, of course, that goes to the policy efficacy of the Act and whether this is the wise policy choice, which, as I'll be coming to, is not, I submit, a matter for this court to consider. Whose plan is better? That's not what the federalism challenge is about. But the key point is that if we are, to the degree we are talking about that, it's not just you get back what you give.
So, Mr. Hunter, I thought you said earlier that the incentive wasn't exactly the same, that there were different levels of incentive.
So there's basically, you get more if you're married and have kids, and you also get more if you live in rural Ontario versus
So the point that you made that rural Ontario long distances is addressed in a policy.
It is partly addressed, but it's not fully addressed. The point being is that rural Ontario, you could be living just outside an urban center, or you could be living thousands of kilometers in Northern Ontario. There's still a flat rate for that. Similarly, an urban center, you could be living in a small town that's still a census metropolitan unit, or you could be living in the middle of downtown Toronto with the transit and other alternatives available to you in that setting. It's a binary choice in the Federal Act, either rural or not rural. So of the measures Ontario is taking, just wanted to point out a couple of them. We are establishing a climate action initiative to help fund, actually drive change, rather than just hope that the market will somehow deliver it. We are consulting right now on industrial emission performance standards. That's set out at tab 7. That it does deal with those who pollute the most, but it's done in a way that's more responsive to the unique needs of Ontario industry, much of which, of course, is in a very trade-sensitive balance. We've all been watching the NAFTA talks and the flight of the auto workers. Ontario's industry is much more trade exposed than the industry in many other parts of the country, and the federal scheme doesn't take that into account in the way Ontario's proposed scheme helps to do. We're also taking measures such as increasing the renewable content in fuels to use less polluting fuels. And we just proposed amendments that, they're on the environmental registry, they're found at tab 8, to increase that several times beyond what the federal government currently does. They currently do 5%, must be renewable. We're proposing an increase to 15% as early as 2025, so triple the limit. And the last point I'd like to make just about the impact of the federal scheme on Ontarians. I mentioned, we need to heat our homes in Ontarian winters. Just to give a good snapshot of the impact this charge is going to have on everyday Ontarians. The Enbridge Gas, which of course is the predominant natural gas supplier in Ontario, is currently before the Ontario Energy Board seeking an increase to its rates because of the coming into force of the Act. Now, to give an example, at tab 10, we have the application for its normal annual cost of living has gone up. And that increase, just their expenses have gone up for inflation, and so ranges, depending on where you are in the province, from $5 to $10 a year. At tab 11, there's the application for the increase solely due to the imposition of the Act. And that increase ranges from $86 to $94 a year. And of course, that's just an average. People who have larger homes, more rural, may have to pay more, but this is just the average rate increase it's asking for. So there's a dramatic increase over the ordinary cost of operations on consumers, and that's just natural gas. The tax will also apply. We've already seen the 4 cents an increase on the pumps. That's going up, as I brought the court's attention to 11 cents, and so on. Now, I'm not going to get into so I expect many of my friends are going to be talking about in the next couple of days about a detailed discussion about the efficacy of a carbon price versus other measures. Quite frankly, that's a policy question. Which measure is the best measure, the most efficient measure, are matters for elected legislators to decide. Which legislature is the question we're here to answer. And the Supreme Court has made that, I would submit, crystal clear in case after case after case. Most recently, in the two security references, which are at tabs 12 and 13. The relevant excerpts are at 12's tab and 13 of the compendium. As the unanimous court put in the first securities reference at paragraph 90, and this is, of course, in the trade and commerce context, but I submit it applies equally well to national concern. One should not confuse what is optimum as a matter of policy and what is constitutionally permissible. Over the page, in talking about the General Motors test, the reference to successful operation should not be read as introducing an inquiry into what would be the best resolution in terms of policy. Efficaciousness is not a relevant consideration in division of powers analysis. And references in past cases promoting fair and effective commerce should be understood as referring to constitutional powers because they are essential in national interests, transcend provincial interests. So on. The courts do not have the power to declare legislation constitutional simply because they conclude that it may be the best option from the point of view of policy. The test is not which jurisdiction, federal or provincial, is thought to be best placed to legislate regarding the matter in question. And the court, next tab, reaffirms that again unanimously in the Pan-Canadian securities reference of last fall. So this reference I submit must be focused solely on what does our Constitution say? What are the division of powers? Once we determine what matters the provinces regulate and what matters the federal government regulate, then it's for Parliament or the legislatures to decide what the best policy is. This court is concerned with legislative competence, not policy. At this point, I would just like to spend a few minutes discussing some of the arguments about other interpretive principles that I understand my friends will be putting forward. And I submit that all of them are inappropriate factors for this court to consider in determining the virus of the Act. And so there are three I will discuss. First, the unwritten constitutional principle of minority rights. Second, Section 35 of the Constitution Act 1982 and the honor of the Crown. And finally, the treaties and the fact that the Act is intended to implement Canada's international commitments, according to its preamble. So first, and I'll deal quite briefly with this, the unwritten constitutional principle of minority rights is quite frankly unhelpful. The Supreme Court recognized in the secession reference that there are these unwritten principles that underlie the Constitution. I will note, of course, that federalism is another equally important one it identified, and I'll be coming back to that. But in deciding the question of should Parliament do it or should the provincial legislatures do it, protection for minority rights just doesn't answer the question. Both levels of government take action to protect minorities. Both levels of government are bound by Section 15 of the Charter. And so it just doesn't help us answer the question. Also, frankly, it presupposes that because a party suggests that the current government at one level of the federal or the provincial level is doing the policy measures it thinks are more appropriate. That should affect the constitutional division of power that must stand for all time. Governments come, governments go. Governments adopt different policies. Which government is, quote unquote, best able to protect minority rights at a given point of time may change the next day. And it's a question by question issue. And it also drags the court into exactly the kind of policy determinations the Supreme Court has said are inappropriate. So I would submit that the unwritten principles just do not help the court address the question that has been asked of it. Similarly, the Section 35 of the Constitution Act 1982, which recognizes and affirms the treaty and Aboriginal rights of our Indigenous peoples, and the honor of the Crown, that requires the Crown to act with honor in its relationships with those, again do not help decide the issue in this case. Under the Constitution Act 1867, which level of government has the power to pass an act like the Act? And I've put in, for the course reference, the Manitoba Métis case and Chilcotin cases, making it crystal clear that, of course, Section 35 applies to the provincial crown and to the federal crown. The crown is one for that purpose. It applies, the honor of the crown binds all the emanations of the crown, not just the federal crown. But again, neither helps answer the question of what is the division of powers on this matter. To be clear, Section 35 was added to the Constitution by the Constitution Act 1982. That act did change the division of powers, but not in Section 35. The division of powers was changed by Part 6, Sections 50 and 51, where they added 92A, dealing with natural resource powers, and the 6th Schedule dealing with the same matter. So there was a clear intention to change the division of powers there. There was no intention to change the powers. The federal legislative power over Indigenous peoples is still found in 9124 and other heads of federal power. There was no change to say just because a matter may have a general impact on Indigenous peoples, that gives the federal government jurisdiction To the contrary, as the Supreme Court has repeatedly reaffirmed in finding that Section 35 and the honor of the Crown bind the provincial crowns, the division of powers is alive and well and must be exercised by both levels of government in accordance with those important principles. So again, it does not help this court decide whether the act is entered by this Parliament. Finally, Canada to some degree, and a number of the interveners say, well, this act must be of national concern because it's implementing Canada's international commitments on a matter of concern not only to the nation, but to the whole world, fighting climate change. Again, I would submit that as a constitutional matter, that is not a conclusion open to this court. The Constitution Act refers to only one treaty power, and that's found at tab 35, section 132. Parliament does have power to implement the obligations of Canada or of any province as part of the British Empire towards foreign countries arising under treaties between the Empire and such foreign countries. And of course, the Paris Accord is not such a treaty. Now, the question then came, well, obviously, as Canada progressed towards an independent nation and started making treaties in its own rights, who would have the power to implement those treaties? Because, of course, in the Anglo-Canadian tradition, a treaty is binding in international law once ratified by the federal executive, but it only becomes binding in domestic law when the necessary legislation is passed to implement it. And so the question came up very early, 1937, soon after Canada had signed the Treaty of Versailles, an independent signatory, dealing with one of the issues that was of national concern of that day, how to deal with the Depression and the Bennett New Deal. And Parliament passed the Weekly Rest and Industrial Undertakings Act, and it was challenged. It went all the way to the Privy Council. And the Privy Council Labour Convention's case made it crystal clear that the fact a federal act was intended to implement an international obligation did not give a freestanding power to Parliament under the peace, order, and good government power. As their lordships found, this is starting at page 352 of the case, which is at tab 36. Actually, I'll actually start on page 351. The second paragraph on page 351.
Which page, sorry?
Page 351. They first talk about the radio case, which was an empire treaty under 132, and the aeronautics case, which was a novel jurisdiction that didn't exist at 1867. But here we're talking about industrial regulation, a matter that, of course, did exist and normally would be governed by the provinces as a matter of local concern. So their lordship was fine. For the purposes of section 91 and 92, that is the distribution of legislative powers between the Dominion and the provinces, there is no such thing as treaty legislation as such. The distribution is based on classes of subjects, and as a treaty deals with a particular class of subjects, so will the legislative power of performing it be ascertained. They go on to talk about the importance of that distribution of powers to our federal structure. And in fact, to Confederation itself. Quebec never would have joined Confederation if Parliament had plenary power just by signing a treaty. And then they go on over the page, the first full paragraph on 352. It follows from what has been said that no further legislative competence is obtained by the Dominion from its accession to international status and the consequent increase in the scope of its executive functions. So the executive did gain the power to sign international treaties. They didn't have to go to Westminster anymore. But Parliament still only had the powers it had before. Now, some of my friends are saying, well, no, we're not asking for a freestanding treaty power. We're just saying that interpreting the national concern power, we should take into account whether it's intended to incorporate or implement an international treaty. And the Privy Council dealt with that as well. They talk about the treaty power, the national concern power in the Ontario v. Canada case, which I'll be coming back to when I get into the depths of that case. And they made it clear, this is about halfway down the page, the Chief Justice in that case, that was the Ontario v. Canada case, naturally from his point of view accepted legislation to fulfill treaties. On this, their lordships have expressed their opinion. But subject to this, they agree with and adopt what was there said. They consider that the law is finally settled by the current of cases cited by the Chief Justice and the principles declared by him. It is only necessary to call attention to the phrase in the various cases: abnormal circumstances, exceptional conditions, standard of necessity, some extraordinary peril to national life of Canada, and so on and so forth. It must not be thought that the result of this decision, this is at the bottom of the page, over the page, is that Canada is incompetent to legislate in performance of treaty obligations. In totality of legislative powers, Dominion and provincial together, she is fully equipped. But the legislative powers remain distributed. And if in the exercise of her new functions derived from her new international status, Canada incurs obligations, they must, so far as legislation be concerned, when they deal with provincial classes of subjects, be dealt with by the totality of powers, in other words, by cooperation between the Dominion and the provinces. And so they were given the opportunity to say, no, we'll expand national concern, and they didn't take it. And just in case there's any doubt that this was, this is an old Privy Council decision from 1937, it's been reaffirmed by the Supreme Court repeatedly, and most recently, just months ago in the Pan-Canadian Security References, which is over the page at tab 37. Paragraph 66. As the Privy Council explained in labor conventions, the valid exercise of the federal government, i.e. the executive's, treaty-making power is distinct from the legislative enactment of such agreements into domestic law. Though the federal government may have the authority to enter into international agreements upon subjects falling within the legislative competence of the provinces, the individual provinces will only be bound by the terms of such an agreement once their respective legislatures enact them into law. So the short answer, I would say, is that this court is bound by those decisions of the Privy Council and the Supreme Court. But I will also say that those decisions make sense in terms of Canada's constitutional architecture. After a long debate over decades, the substantial majority of the provinces and the federal government agreed on an amending formula so the Constitution can be patriated. And for matters involving the division of powers, that amending formula is 7 provinces with 50% of the aggregate provincial population, plus the federal parliament. The legislatures of those provinces. Parliament, not just the federal executive. If the federal government, by the stroke of a pen on an international treaty, could amend the division of powers, could indirectly do so by expanding the scope of the national concern branch, that would undermine those very safeguards that all but one province and the federal government agreed on, and that was passed into our Constitution. And the Supreme Court talks, I put in the extras from the Senate reference, that constitutional architecture, that intention must be given effect to in interpreting the amending formula. So just as the previous federal government could not make the Senate an elected body by agreeing to only appoint people who'd won consultative elections, because that would essentially be an amendment to the Constitution without provincial consent, so too can the federal executive not give Parliament greater powers by signing an international treaty. The way to amend the division of powers is by a constitutional amendment. And that, in fact, has been done when there was a need for more powers for the federal government to meet matters of the day. When the Privy Council struck down early federal attempts at enacting old age security and employment insurance, the Constitution was amended to give Parliament those powers with provincial consent. When there was doubts in 1982, the very time the amending formula was being passed, about the proper role of the provinces over their natural resources, an amendment was agreed. Those amendments should not be made through the back door because Parliament has signed a treaty. The question is, irrespective of the international law obligations Canada may have, what are the requirements of our domestic constitution? And that is what I propose now turn to.
Just on that, Mr. Hunter, on the 3 points you've just talked about at some length, the unwritten principle of minority rights, Section 35 of the Constitution Act 1982, and Canada's treaty obligation. All of those 3 points are made in some way by some of the interveners. Not one of them has anything to do with the federal government's position in arguing the distribution of powers issue here, correct?
That's my understanding, although of course I'll my friend says tomorrow.
Yeah. There's nothing I've seen where they argue any of that.
No, I don't. The only thing that I would say is that the treaty power, which is why I spent the most time on that, there is reference to the preamble of the Act and the importance of the Act. When assessing whether the matter is of national concern, they do rely, and they have evidence, they've submitted affidavit evidence on whether the Act being unconstitutional would impact Canada's international commitments and whatever results that may have for future international relations. My submission is that those are not relevant to whether the matter is of national concern in the constitutional sense. I agree the other points were dealt with primarily by the interveners. I just thought it was more convenient to deal with at this point in the analysis rather than just saving it all for a reply.
Okay. Just going to ask you one question about the principle of interpretation. You haven't mentioned it, but there is a principle of interpretation that says that courts should strive to find a harmonious interpretation of statutes so that they can live together and so you can have overlapping jurisdiction between provincial and federal legislation. You may well be coming to this later in your submissions.
That's actually where I was going to start the national concern discussion with.
Well, then that's fine. Then
So
feed it in.
I'll turn that right now. That's actually the principle of federalism. And yes, the general principle is that where possible, matters should be allowed to coincide. But as the court has repeatedly, Supreme Court has repeatedly said, that cannot swamp the division of powers out to sea. And there's a quote from the Securities Act reference, which I would submit. It's at tab 14 of the compendium, paragraph 7. And what I think encapsulates the proper approach to that in this circumstance. So it's paragraph 7, and then I'll go on to paragraph 61 and following. So at paragraph 7, the court says, again, it's unanimous court, it is a fundamental principle of federalism that both federal and provincial powers must be respected, and one power may not be used in a manner that effectively eviscerates another. Rather, federalism demands that a balance be struck, a balance that allows both the federal parliament and the provincial legislatures to act effectively in their respective spheres, and I'll be coming back to that. Accepting Canada's interpretation of the general trade and commerce power would disrupt rather than maintain that balance. Parliament cannot regulate the whole of the security system simply because aspects of it have a national dimension. And the court goes on to reaffirm that, paragraph 61 and 62. While flexibility and cooperation are important to federalism, they cannot override or modify the separation of powers. Paragraph 62. Notwithstanding the court's promotion of cooperative and flexible federalism, the constitutional boundaries that underlie the division of powers must be respected. The dominant tide of flexible federalism, however strong its pull may be, cannot sweep designated powers out to sea, nor erode the constitutional balance inherent in the Canadian federal state. And I would submit that just as Parliament's securities reference overreached, Parliament here is overreaching. It is seeking to compel the provinces, who have clearly undisputed jurisdiction to combat climate change within their own boundaries, to adopt the federal government's preferred policy approach.
But nothing in the Act stops Ontario from doing all the things that you've described.
No, but it does require, but it doesn't count any of them to deciding whether we have a sufficiently
No, but
stringent.
it doesn't prevent Ontario from doing any of those things.
No,
It
but
simply says you have to put a price on carbon.
That's what the current act says.
Yeah.
The claimed head of federal power, and
Well-
I'm about to get to, would do far more. And when we're assessing under the national concern branch whether a new matter should be recognized as federal jurisdiction.
Just for now, would you agree that the current act, the act that we're talking about, does not lead to that, does not do that?
It does not prohibit Ontario from taking any action. No. It may make it impractical to do things in a way that Ontario's government and Ontario's legislature feels are the best way to do it.
How's that?
Because Ontarians would still have to pay the taxes under the federal plan. And so if Ontario is saying that having a tax-based scheme is harmful to Ontarians, as it has said, there's no way for it to avoid that if the act is constitutional.
But it doesn't prevent Ontario from taking any steps to improve environment.
No. But what it does do is say that even if Ontario reduced its carbon emissions 30, 35%, as much as the federal government has asked Ontario to do or more, they're still going to have to pay this tax because they haven't done it by a pricing scheme. If you don't do it by a pricing scheme, that's not good enough.
So I think it's conceded that these gases don't have boundaries. And you say Ontario has done a great job. It's reduced carbon emissions by 22% since 2005. Looking at the chart that you directed us to at tab 4, looking at our neighbor a couple of provinces over, Saskatchewan is up by 10.7%. Ontario's down 22%. In terms of protecting Ontarians and achieving the objectives that Ontario wants for the life of Ontarians, how do you address the problem that some provinces don't seem to be doing what Ontario's doing without this kind of legislation?
I'd say that's a matter for cooperation and agreement. If the federal government wants to use its taxing power to provide incentives to provinces, provide funding to provinces and encourage, that's fine. What I say is not permitted is for Parliament to say this is now a new matter of national concern and we can regulate all aspects of it as we see fit, and we don't have to let the provinces decide what best meets their circumstances. Now, we have put in the record the plan that all the other provinces have. The other provinces do have plans to reduce their carbon emissions. I don't want it to be suggesting they do not, and those plans are not effective. I'm sure my friends from Saskatchewan and New Brunswick will comment on those plans. The point being is that we're a federation. Matters of great national importance, healthcare, inflation, dealing with the Depression, all these matters that were the crux of the concern of the country at their respective times. The Constitution does not always say, oh, it'd be great if there was a one decision maker. Federalism doesn't provide that. There are 13 decision makers, but they work together to achieve those national goals in a way that respects their local concerns, and that the Constitution can and should permit them to do.
But I don't hear Canada saying we are going to regulate all manner of activity that produces greenhouse gas. They say what we're doing is we're imposing a national pricing scheme.
So what they say, though, is that when we challenge the constitutionality of it, they say their primary ground is that that's supported under the national concern because cumulative greenhouse gases are a matter of national concern. And I'm going to be spending a fair bit of time.
That's not the argument they're making here. They're talking about the cumulative effect, national cumulative effect.
They're saying that the cumulative greenhouse gas are national, and I plan to submit that that is a distinction without a difference. That is not the kind of qualitative difference between regular market risk and systemic risk that led to the differing results in the two security references. Here, it's just adding it all up. And if the federal government had that power to regulate the cumulative aspects of greenhouse gases, they could regulate any activity that produces greenhouse gases because they all contribute to the cumulative amount. They could regulate where you live, how often you drive your car, what kind of land use planning you have, what kind of materials used in construction, how we build our schools and our hospitals, all matters of quintessentially provincial concern.
Eketer says in response to that that's adjusted by simply refining what we characterize as the pith and substance of the legislation to dealing with the cumulative effect of greenhouse gas emissions through a pricing mechanism.
Well, that's really answering the question by defining the question away. And that really gets into the...
But does that not address your concern about that this would permit the federal government to interfere more broadly with regulation in Ontario?
No, because they could place a pricing mechanism on all those activities that impact the daily lives of Ontarians. fine, they're limited to, first of all, I would say it's...
So your concern is not about, now they're talking about pricing, and next they're going to be talking about shutting coal plants or doing any other kinds of things. Your focus or your concern is on the pricing.
My concern is that they have argued that a new head of federal power should be created in the National Concern Doctrine. That's essentially what the National Concern Doctrine does. It says, here's a new matter adding to the list in 91 that gives them the power to use the federal government's language, cumulative greenhouse gas emissions, to use ecofiscal's analysis, regulating greenhouse gas emissions through pricing. Either way, there's no qualitative distinction. You can't draw a line between what's clearly intraprovincial activities, regulating local industries, land use planning, public works. Those are all matters that are clearly governed by 92. All of those would be transferred to the federal government as long as it was in some way related to cumulative greenhouse gases or pricing greenhouse gases. There's a million ways you can call something a price. So no, my submission is that giving the federal government power over either of those definitions, it's not single, indivisible, and united as required, and it would unbalance the federation, and therefore it doesn't meet either branch of the national concern test.
I don't quite understand why you would assume that Canada would act in an unconstitutional manner in regulating an aspect of the issue that falls within provincial jurisdiction.
Well, that's my whole point, is that if their argument's adopted, it wouldn't be unconstitutional. They would have jurisdiction. And that's an important distinction. So really, normally when you're doing a pith and substance analysis, you first look at the act and characterize it, and then you assign it to a head of power. And that makes sense when you've got an enumerated head of power. National concern's a little different, and I'm about to actually take to the text that defines it. Because there is no list, the whole point is you have to figure out what is the matter. So I suggest it makes sense analytically to start with the matter first that Parliament is claiming. And I would submit, obviously, Parliament's definition is the one this court should be considering. And Parliament has said, we want jurisdiction over the cumulative aspects of greenhouse gases. Now, I'll come back to why I don't think the Act is so limited to those aspects, but even if it were, that head of power is a massive expansion of federal jurisdiction. And it wouldn't just give Parliament jurisdiction to pass this Act. To give just one example, if an anti-carbon pricing federal government were to be elected, a power to regulate the cumulative aspects of greenhouse gases would include the power to occupy the field. Now, I don't go so far as some who say that this Act itself ousts. I agree with Justice Sharp. This Act does not oust Ontario's ability to regulate climate change. But a federal power over greenhouse gases would allow Parliament to pass legislation saying, we're the only ones who are deciding what to do here. Because we're talking about the matter. We're talking about what is the head of powers for all future federal governments. I mean, look at the other matters of national concern. They're all matters that have been used far more than the original Act that was at question in the case. National Capital Region, aeronautics, nuclear power. These are all matters that there's extensive regulatory acts far beyond the one piece of legislation that was at issue in the original case. So we have to look at the scope of the power as a whole, not just its application. I do say this Act also goes beyond the scope of the power they've claimed. But our key point is the power claimed is just too broad.
So in Crown-Zellerbach, there's language which suggests you have to look at the particular legislation and see how carefully balanced it is. Is it more intrusive, necessary? And if that goes into the determination of the constitutionality, then doesn't your concern about the broad federal powers net somewhat abated?
Well, it depends again on how the power is defined. If you define a power over cumulative greenhouse gases, any act that in purpose and effect is intended to deal with cumulative greenhouse gases would be inter vires that new power. And you don't sit there and say, again, you don't go too far, take that language too far and say, oh, well, this particular act, it's within the four corners of the power, but we think there's a policy concern with it, so it's ultra vires. You do that by defining what those four corners of the power are. So what I propose to do on the national concern branch, and I'm happy the court's direction as to when, unless you'd like to take the morning break, I was going to start with the actual text, first of all, what the power comes from, And then I was going to go through the leading cases and address what we say that test is not met by the claimed federal power. And then finally, we'll come back to the Act itself and its characterization in terms of if the power is accepted, why we say the Act still would go beyond the scope of that power.
I think if you're content to do so, we should go to about 11:30 and we'll break then as
Certainly.
convenient.
Give me a chance to talk about the Act and some of the early cases, and then we'll get into the big cases of Crown Zellerback and Hydro-Quebec after the break.
Before you get onto that, I want to follow up just in terms of the magnitude of the potential federal power here. Would it be the case that instead of having a uniform price for a particular emission, the federal government under this power could have sectoral specific pricing?
Yes.
You could do that. You could say, here's the price for greenhouse gases emitted in manufacturing versus mining versus oil sands. You could do that?
Yes.
And at the same time, it would reach right into, could the federal government say, regulate fireplace use in homes?
Yes.
Could they prohibit the use of wood-burning fires in homes?
Absolutely.
All right.
And just to give some examples of some of the other things it could do under its claim power, because remember, all greenhouse gas emissions impact the cumulative total, it could impose restrictions on zoning. It could say that you need a certain density of population in all new builds in the province. It could say, as some other countries have done, to deal with smog and greenhouse gases, there's a license plate lottery, and you can only drive 3 days a week, and everyone has to take their turn on which 3 days they get to drive. They could require, a certain maximum area, so we preserve greenbelt and areas for reclamation of carbon. Now, even on a pricing mechanism, it was put by Associate Chief Justice that, well, if it's pricing, but you could do that through pricing. So the fact that it's a pricing mechanism isn't actually a real limit on that power. You could say, if you buy a house if you provide a house in downtown Toronto, where it's urban density and you've got good transit and everything, the tax would be this much. If you want to build a new house on greenfield land, not connected to any, the price is going to be this. You can do it through pricing. You can influence behavior through pricing and whatever the reach is. I should note also that Part 2 already provides separate targets for each sector. The output is different, so the actual what your limit is sector dependent. So remember that the emissions charge is a charge for excess emissions over your limit of however many tons of CO2 equivalent. That is set on a sector by sector basis. So they in fact already have started to treat some sectors differently.
So just so that I'm clear then, your submission would be that anything that contributes to greenhouse gases, anything, like my colleague's suggestion of the fireplace in a home, would be swept under federal power in this notion.
Yes, because their claim power, and that really goes to the heart, and I'm going to deal with that when I want to go a little bit through the history, but really that's the securities and the Pan-Canadian securities reference. Those are, of course, our trade and commerce cases, but I think both we and Canada agree they're relevant to the national concern analysis. The key difference between why the first act was struck down and the second proposed act was upheld was that there was a qualitative difference between what the feds were regulating in the second act. The systemic risk they were regulating wasn't just adding up all the risk of the individual market participants that provinces regulate. It was actually of an order of magnitude difference, and I'll go with that in more detail after the break. But there was actually, you could actually say the differences. Even in Crown Zellerback, marine pollution was qualitatively different than inland like freshwater pollution. There was something about it that was actually beyond the types of matters the provinces regulate. Here, we're adding up a large number of provincial heads of power, putting it in a package and saying, well, because there's international commitments and it's really important, it now has to be national. And all the past examples, like inflation, hours of work, and regulation of trades during the Depression, they've been rejected because those in a federation are matters that have been given to the provinces and should remain there. And that is reflected by the very text of the Constitution. And I'd just like to turn to that briefly because I think the opening words of Section 91 are instructive about how the national concern doctrine must be interpreted more narrowly than Parliament's enumerated powers. So that's found at tab 15 of our compendium. I'm actually going to start with section 92, which is the provincial list of powers, and the opening words there. In each province, the legislature may exclusively make laws in relation to matters coming within the classes of subjects next and hereinafter enumerated, that is to say, and then there's the list. And similar language is used at the beginning of 92A and 93. And then they go on to the very rare concurrent powers, old age security, agriculture, and immigration. The general rule under our Constitution is provincial powers are exclusive. But there's an exception. The opening words of section 91. It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada, there's that POG power, in relation to all matters not coming within the classes of subjects by this act assigned exclusively to the legislature of the provinces. So the general rule is that the POG power is only for matters that don't come within the provincial list. But there's then an exception to the exception. For greater certainty, but not so as to restrict the generality of the foregoing terms of the section, it is hereby declared that notwithstanding anything in this act, i.e. notwithstanding 92 through 94, the exclusive legislative authority of the Parliament of Canada extends to all matters come within the class of subjects next, hereinafter enumerated, that is to say. And then there's the federal list. So the federal enumerated powers apply notwithstanding the exclusivity in 92 to 94. POG does not. And that is why the Privy Council and the Supreme Court have always taken great pains to carefully delimit those powers, more than the enumerated powers. I mean, the enumerated powers, of course, all have their own internal limits because we don't want either list to swamp the other, but POG is special because POG is an exception to the normal rule. The framers carefully went through the list and decided this is what should be federal because they're important to the nation as a whole. This is what should be provincial because their matters were local choice matters. And they carefully considered that. It was a matter of intense negotiation at Charlottetown and at Quebec, and then again in London. POG, but there has to be some matters that weren't thought of. They just didn't exist. No one can even think about them in 867. I will note, pollution and greenhouse gases is not one of those matters. You look, and my friends have put in some of the industrial regulation in England, people knew about smog and pollution. We didn't know the exact chemical way it worked, but we knew that pollution was bad and that industry produced pollution. It was not a new concept in 1867. Just look at Manchester in the 1860s, and people knew it very well. Secondly, there's the emergency branch, and I'll come back to that in reply. I don't think Canada is not relying on the emergency branch, so I'm not going to deal with that now, but I will come back to it if my friends, as I expect they will, raise it in the interveners' arguments. That was carefully delimited because it has to be temporary. It has to be an emergency, because otherwise it gives the federal government power over everything. And the third branch is the national concern branch. And that, from its very beginning, has been carefully delimited because, again, you want to take care not to swamp the federal-provincial division of powers. And I'm just going to turn to one case, I think and then it would be a good time to stop, because the very first case, Ontario v. the Dominion, which is at the next tab, tab 16. The Privy Council accepts, about middle way down the page, that there may be matters, not including the enumeration, upon which the Parliament of Canada has power to legislate, because they concern the peace, order, and good government of the Dominion. But to those matters which are not specified among the enumerated subjects of legislation, the exception from section 92, that's the notwithstanding I referred to, has no application. And the Dominion Parliament has no authority to encroach upon any class of subjects exclusively assigned to provincial legislatures by section 92. Over the page, they accept that there are some matters, this is at the bottom, their lordships do not doubt that some matters, in their origin local and provincial, might attain such dimensions so as to affect the body politic of the Dominion, and to justify the Canadian Parliament in passing laws for their regulation or abolition in the interest of the Dominion. That's the genesis of the national concern power. But from the very beginning, there's a warning label. Great caution must be observed in distinguishing between that which is local and provincial, and therefore within the jurisdiction of the provincial legislatures, and that which has ceased to be merely local or provincial and has become matter of national concern in such sense as to bring within the jurisdiction of the Parliament of Canada. When we return from the break, I propose to go through the case law and show how that caution has been applied and discuss why it should apply to this act and this claimed head of federal power.
Thank you. We'll rise for 20 minutes.
Court resumes. Please be seated.
Yes, Mr. Hunter.
So turning now to the Supreme Court's case law on the national concern test. I'm going to start, just going to do them in historical order, it probably makes the most sense. So the first one is
Just,
at
Mr.
tab
Hunter,
7.
Mr. Hunter, can I just ask you a question? You outlined your order just before we broke for lunch, and I just thought about it. Normally, when we're at this point, it's 2 steps of analysis, and only 2. Number 1 is characterization. What do you say the subject matter is? And number 2 is classification, which is the law. And I heard you say you were going to move to the classification and the legal analysis now, and then apply it to the other steps. So, and your factum does it in the traditional order, and you're about to do it in the reverse order. And I just am wondering, am I right in that, and why?
Well, you are right, Justice McPherson. The reason for that is because of the unique nature of the national concern power. Because normally, when you are doing the 2-step federalism analysis, you look at the act and what in pith and substance it does. The short version is it's imposing charges on all fuels and all greenhouse gases emitted by industrial emitters, Part 1, Part 2, respectively. Not just those that actually have a significant effect on the cumulative emissions. It can be quite small amounts. It could just be someone filling up 1 tank of gas. That being said, the reason why I do plan to say why I think that goes beyond the claimed head of power, cumulative emissions from greenhouse gases. But the real crux of this case is, does the federal government have power over that claimed power in the first place? So what I want to focus my arguments in oral argument was on that second question of what is the head of power? And I submit that makes sense in the national concern context because there's not a list. The whole point of national concern is the federal government is trying to argue we should create a new item. We should transfer power that otherwise would be provincial, because no one disputes the provinces could enact something like the act if they so chose, and some provinces have so chose. The question is, does Parliament have this power to regulate the cumulative aspects of greenhouse gases? And I think that question logically does need to be discussed first, because if we don't know what the scope of the power is, how can we classify the act and assign it to it?
Okay.
So turning then, so there's really 4 major national concern cases, and then the securities cases, which are somewhat relevant, although they must be treated with a little bit of care because they are dealing with an enumerated power that does have to have a minimum content. There does have to be some federal general trade and power scope. The Constitution doesn't require there to be some basic minimum federal cumulative greenhouse gas emission scope. It could quite feasibly be left 100% to the provinces. But starting with the first one, the Inflation Act reference. So again, I would suggest this case actually bears a lot of analogies to the case before the court today, in the sense that in the 1970s, of course, inflation was the burning issue of the day and Canada argued required a national response. And it couldn't just be left to what would otherwise be provincial. And so the court split three ways on the question of national concern. The Chief Justice who wrote the majority decision on the emergency power, which I'll come back to if we need to deal with emergency and reply, said, I don't even need to talk about national concern because I find I can uphold it under the emergency branch of POG, so I don't need to consider the issue. Justice Ritchie, which is on the second page of the excerpt, agreed with Justice Betts on the national concern point, although they disagreed about emergency. So really it's Justice Betts' reasons I'd like to take the court. A detailed examination of the dangers of an overly expansive interpretation of national concern. And this starts at page 443. Justice Betts says, some of the extremely far-reaching consequences of this submission must be underlined with respect to the so-called subject matter of inflation or its containment. That was the national concern alleged matter in that case. Sounds somewhat similar, inflation or its containment. National concern submission. It must be conceded that the Anti-Inflation Act could be compelled extended to the provincial public sector. And they talk about why Parliament hasn't done so. Parliament could also regulate wages paid by municipalities, educational institutions, hospitals, other provincial services. Parliament could occupy the whole field of rent controls. In times of inflation, there's a great deal of speculation in certain precious possessions. Parliament could control those. Over the page, they could ration food, everything else, to prevent hoarding unfair profits. One could even go further and argue that since inflation and productivity are greatly interdependent, Parliament could regulate productivity, establish quotas, impose the output of goods or services, which corporations, industries, factories, groups, etc., produce in any given period. Indeed, since practically any activity or lack of activity affects the gross national product, and I would submit affects Canada's cumulative greenhouse gas emissions, the value of the Canadian dollar and therefore inflation, it's difficult to see what would be beyond the reach of Parliament. Furthermore, all those powers would belong to Parliament permanently, and that was my point about why the analysis should not be limited to this act alone. Only a constitutional amendment could reduce them. Finally, the power to regulate and control inflation as such would belong to Parliament, legislatures, if it is contended the power to vest in Parliament in the same manner as other examples of national concern. The provinces could probably continue to regulate profit margins, prices, dividends, and compensations if Parliament saw fit to leave them any room. But they could not regulate them in relation to inflation, which would have become an area of exclusive federal jurisdiction. Goes on page 445. Well, what about the argument that this is so important? If the first submission is correct, this is the third paragraph. It could also be said the promotion of economic growth, or the limits to growth, or the protection of the environment, prescient perhaps, have become global problems and now constitute subject matters of national concern going beyond local, provincial concern or interest and coming within the exclusive legislative authority of Parliament. It could equally be argued that older subjects, such as business of insurance or labor relations, not specifically listed in the enumeration of federal and provincial powers, have outgrown provincial authority whenever the business of insurance or labor become national in scope. It's not difficult to speculate as to where this line of reasoning would lead. A fundamental feature of the Constitution, its federal nature, the distribution of powers between Parliament and the provincial legislatures, would disappear not gradually, but rapidly. And therefore, Justice Betts concludes over the page at 458, second full paragraph, the containment and reduction of inflation does not pass muster as a new subject matter. It is an aggregate of several subjects, some of which form a substantial part of provincial jurisdiction. It is totally lacking in specificity. It is so pervasive that it knows no bounds. Its recognition as a federal head of power would render most provincial powers nugatory. And I would submit that if you replace the section in the quotations with the cumulative greenhouse gas emissions, this analysis would apply equally well to what Canada claims is federal jurisdiction today. My friends, of course, respond, but what about Crown-Zellerbach? I submit Crown-Zellerbach is not analogous to this case. So turning over to the next tab, tab 18, Justice Ledane wrote for the majority, and on the facts, found that marine pollution was a matter of national concern. Justice Laforêt, at this point, wrote for the dissent on the dangers of a more broader recognition of certain environmental matters. I'll say at this point because it later becomes the finding of the majority of the court in Old Man River. But let's start with what Justice Ledane has to say about the test for national concern. So he sets out at pages 431 and 32, 4 points. And it's the third and fourth ones I would submit are relevant to the questions before the court today. First factor. This is point 3 in his analysis on page 432. For a matter to qualify as a matter of national concern, in either sense, it must have a singleness, distinctiveness, and indivisibility that clearly distinguishes it from matters of provincial concern. That's point 1. Part 2 of the test, and a scale of impact on provincial jurisdiction that is reconcilable with the fundamental distribution of legislative power under the Constitution. So there's 2 tests. There has to be something different about the matter that distinguishes it from provincial matters. And even if that step is met, recognizing federal jurisdiction over this matter must not imbalance the division of powers. You can't swamp provincial powers. Now, the second point, and I think my friends will like their facts and certainly focus on this point, in determining whether a matter has attained the required degree of singleness, distinctiveness, and indivisibility, it is relevant to consider what would be the effect on extra-provincial interests of a provincial failure to deal effectively with the control or regulation of the intra-provincial aspects of the matter. That's the so-called provincial inability test, and ultimately didn't go that far. But before I get into what it did do with that test, I just want to note how that fits into the analysis. It is not a separate test. There are 2 tests. 1, single distinctiveness and indivisibility. 2, reconcilable with the fundamental distribution of legislative power. The provincial inability is merely an indicia of step 1. And the federal claim power has to pass both steps to be a valid new matter.
Could I just ask you to pause for a moment on singleness, distinctiveness, and indivisibility? Is that, I have some challenge with that. Is it one expressed in 3 different ways, or are they 3 different concepts? And is there some way you can capture singleness, distinctiveness, and indivisibility in a word or phrase other than what it says?
Qualitatively different is how I would characterize it.
Qualitatively different?
Not just quantitatively. And then I would submit that the analysis the Supreme Court does in the subsequent trade and commerce cases, the General Motors test has very similar factors, and the analysis they do about why a national securities regulator writ large is unconstitutional, but a limited federal regime dealing only with national systemic risk is constitutional, is because of that qualitative difference. And I would submit Crown-Zellerbach also turns on a qualitative difference between marine pollution and lakes and river pollution writ large.
The 2 points you've just read, points 3 and 4 from Crown-Zellerbach, would you agree with this, that those 2 paragraphs are today the test for the national dimensions component of peace, order, and good government. That what came before, anti-inflation, which is really very close in language, and what comes after, including in the trade and commerce cases, all that language is contextual, it's historical, it's interesting, but the test for this case is the 2 paragraphs you've just read to us.
I would say that these 2 paragraphs, properly interpreted with 4 subordinate to 3, is the test as interpreted and modified in the subsequent case law. So they haven't changed the test, but they have provided interpretative glosses that are important for the court to consider. And that's why, in answer to the Chief Justice's question, I said that if you look at this case through the lens of the considerably more recent case in the securities reference, which Canada agrees should be used to interpret the national concern branch as well, that shows what they were talking about. They were talking about a qualitative difference, not just, oh, provinces can regulate this and this and this, and if we add it all up together, it's now the cumulative dimensions. But the key point there is that paragraph 3 sets out the 2 branches of the test. Paragraph 4 shows one indicium that is relevant but not determinative of the first branch of the test. It is not a standalone part of the test, as some of my friends try to suggest it is. And that's made clear by Justice Ledane on page 434. In this sense, the provincial inability test is one of the indicia for determining as the character of this relatedness of the interprovincial and extraprovincial aspects that it requires a single or uniform legislative treatment. The provincial inability test must not, however, go so far as to provide a rationale for the general notion, hitherto rejected in the cases, that there must be a plenary jurisdiction in one order of government or the other to deal with any legislative problem. Helpful tool. And that's really important here, because really boiled down, Canada's argument is this problem is so important, it cannot be left for the provinces to find their own solutions. There has to be a one-size jurisdiction. And that is not what labor conventions held about the New Deal. That's not what the Inflation Act held about inflation. And I would submit it's not what this court should decide about climate change. On the specifics of the federal power at issue in Crown-Zellerbach, Justice Ledane goes on to have some concerns about it. Say, this is at the bottom of page 447. As I see it, the potential breadth of federal power to control pollution by use of its general power is so great that even without resort to the specific argument made by the appellant that marine pollution was offsides, the constitutional challenge in the end may be the development of judicial strategies to confine its ambit. It must be remembered that the POG clause can comprise not only prohibitions, like criminal law, but regulations. And so he goes on to say exactly the kind of things I've been discussing about the scope of potential federal regulation if they're given a broad power over pollution or even specific kinds of pollution. So the final point I'd take from Justice Ledane's is what was actually the nature of the matter. I'm sorry, I should have misspoke. That was actually just Laforet issuing the caution. It wasn't Ledane. But Ledane, I just want to point out, the pollution at issue there was marine pollution. And that's not just ocean pollution. It was basically marine pollution in things like the Straits of Georgia or the Gulf of St. Lawrence. It was pollution that was in salt water that had a chemically different effect from pollution produced by interprovincial sources. So the evidence in that case was that pollution into salt water was actually a different kind of pollution than pollution to freshwater. Even though pollution in freshwater, most pollutants would eventually make their way down to the watercourses to the ocean. There was actually something different. In this case, the whole point is that intraprovincial pollution and extraprovincial pollution are the same. There is no dividing line that can be drawn, and there is no qualitative difference between what everyone acknowledges the provinces can regulate greenhouse gases produced by local industries, local activities, and what the federal government claims, the cumulative impact. Except for the narrow list of things governed by Part 3 of the Act, which we don't oppose, all of those cumulative aspects are just the sum total of the 13 provincial and territorial. Quality difference, like
Well,
there was.
Isn't the argument, as I understand it, is that it's the cumulative effects that cause climate change. It's not the campfire or your furnace or your fireplace. It's all the cumulative effects mixing together and causing climate change, regardless of what province or what house or what factory they came from.
And that's exactly the problem with recognizing this as a federal head of power. Production of this particular natural resource and add it all up, there's no way to draw the line as to where the federal matter ends. Here, in Crown-Zellerback, there was a clear division. It ended at the freshwater, saltwater boundary. You could know where it stopped. Because remember, the default under the Constitution is that POG is an exception to the norm that all matters are covered by the federal and provincial enumerated powers.
Isn't the difference with Crown-Zellerback, marine pollution had an effect outside the province, whereas freshwater pollution did not? So you had a demarcation there between something that had an effect that beyond the limits of the province, and therefore could be conceived of as a matter of federal jurisdiction.
Well, the problem there, though, is that freshwater pollution, in many cases, did have an extra provincial impact. That's not where they drew the line. They drew the line at marine, saltwater pollution.
But if freshwater pollution that has an interprovincial impact is subject to federal regulation, is it not under the IPCO case?
As an ancillary aspect of an enumerated power,
yeah.
not as a new head of freestanding federal jurisdiction or national concern. We're not debating that the federal enumerated powers can, in appropriate circumstances, have impacts on climate change. And we keep putting the example, for example, they can ban outright the use of coal in generation under the criminal law power. They can, under the Species at Risk Act, you can have impacts. You can require federal environmental assessments under the transportation and navigation powers. That's not the point. The point is, should there be a freestanding plenary federal power that has the ability to govern virtually all matters in the province? Justice Betts in inflation said no. Justice Laffer, as I'm about to come to, warned of the dangers of such an approach, didn't need to go there on the facts for the majority because there was that demarcation. Marine pollution was qualitatively different, not just quantitatively different, because it's not just the sum of all the freshwater pollution in the country that eventually makes its way to the sea. It's that pollution of materials into the marine environment, which has different chemical circumstances than the freshwater environment. And so turning to those dangers, and as I said, I started speaking of them a minute ago, Justice Laffer was quite concerned about the possible scope of the claimed national concern power. And he warns at page 452 and following of why the national concern power has to be read narrowly. Retain a national dimension that are distinct from provincial regulation. But he warns, the need to make such characterizations from time to time is readily apparent. From this necessary function, however, it is easy, but I say it with respect fallacious, to go further, and taking a number of quite separate areas of activity, some under accepted constitutional values within federal, and some within provincial legislation, under the Constitution. By conceptualizing broad social, economic, and political issues, industrial regulation, inflation, pollution, climate change, as examples, one can effectively invent new heads of federal power under the national dimensions doctrine. thereby incidentally removing them from provincial jurisdiction or at least abridging the province's freedom of operation. And he goes on, I'm not going to read all the quotes, there's a lengthy discussion of the concerns of that. He quotes the passage I just took you to from the anti-inflation reference, and then says at the bottom of 454, what was there said by Justice Betts seems to me to apply a fortiori to the control of the environment, a subject more germane to the present issue. All physical activities have some environmental impact. Possible legislative responses to such activities cover a large number of the enumerated legislative powers, federal and provincial. To allocate the broad subject matter of environmental control to the federal government under its general power would effectively gut provincial legislative jurisdiction. And he goes on to narrow and say, well, and even if we're not talking about the environment writ large, if we're just talking about pollution, the same concerns apply. Over the page on 456, the bottom around letter B. As Justice Betts in the Inflation Act stated of the proposed power of inflation, there would not be much left of the distribution of power if Parliament had exclusive jurisdiction over this subject. For similar views, the protection of environmental pollution cannot be attributed to a single head of legislative powers, see Peter Hogg and Baudouin. It is true, of course, that we are not invited to create a general environmental pollution power. And the majority marine was too far.
Justice Lafrey is a dissent.
That's what I was saying. He was in dissent there.
So
he wasn't in dissent in the
why
next.
all the attention to Justice Lafrey?
Because the unanimous court adopted. Justice Stevenson, if I remember correctly, had a concurrence, but not on this point. Yes, Justice Stevenson dissented on other grounds, but agreed with Justice Lafrey. So this was speaking for the unanimous court on this point. So starting on page 63. I agree the Constitution Act does not assign the matter of environment sui generis to either the provinces or Parliament, that it's mixed. I earlier, over the page on 64, I earlier referred to the environment as a diffuse subject, echoing what I said in Crown-Zellerbach, to the effect that environmental control as a subject matter does not have the requisite distinctiveness to meet the test under the national concern doctrine as articulated by Justice Betts in Anti-Inflation Act. Although I was writing for the minority in Crown-Zellerbach, this opinion was not contested by the majority. The majority simply decided that marine pollution was a matter of national concern because it was predominantly extra-provincial and international in character. It was qualitatively different. It was dealing with those matters that the provinces just had no power over and implications, and possessed sufficiently distinct and separate characteristics. That's that chemical difference in how the pollution works I was referring to, as to make it subject to Parliament's residual power. Goes on, I'm not going to go through it in detail, but a lengthy discussion of how, there are many of the enumerated powers that may cover different environmental matters, but that you don't need to refer to the national concern branch. So that analysis and those concerns I was referring to in Crown-Zellerbach became the views of the unanimous court in Old Man River, which is why I was referring to the Justice McPherson. And they actually say in Old Man River, let's look at the enumerated powers first. Let's use our, as is the norm, as was referred to earlier, the province have their enumerated powers, the feds have their enumerated powers, both can apply them. You don't need to take the extreme step of creating a whole new plenary head of federal power under the national concern doctrine with all the dangers that poses to the balance of the Federation. Just for completeness, I will note that Justice Lafrey repeated his views. Again, it was a minority decision because the majority decided the case on the criminal law power in the Hydro-Quebec case. And he, of course, points out that the whole court agreed with him on what the proper analysis was. So, turning to the two branches of the test and why I submit they do not apply. The first branch is that it has to be single, indivisible use. That is, as I suggest, the proper way of saying that it has to be different. There has to be something different about this head of power that's proposed that distinguishes it from matters that would otherwise fall within provincial jurisdiction. And that is not met here. Now, my friends point to, but there's a list. We know which chemicals we're talking about. It's the chemicals that create greenhouse gases. That's not enough. I mean, they may be chemically distinct, but I would submit they're not constitutionally distinct. The matter isn't what are the chemicals you're regulating. It's what's the impact? What powers does that give you as a legislature? And so the head of power that they've claimed, cumulative impacts of greenhouse gases. And I would say, let's start with greenhouse gases, and then I'll deal with why cumulative doesn't actually add anything. It's an adjective that doesn't really qualify the scope of the power. As I've already mentioned, regulating greenhouse gases would give Parliament the power to regulate, not just prohibit, as the court made clear, all activities that cause greenhouse gas emissions. And just as with inflation, that means basically all human activity, because almost everything humans do has an impact on greenhouse gas emissions. How they drive, where they live, how they heat their homes, all those matters. Does cumulative provide a useful limit?
I'm sorry, I didn't hear this. Does cumulative?
Provide a useful limit. Because the federal government, in its factum, says, unlike what we argued in Saskatchewan, where we said it was just greenhouse gases, now we're saying, no, it's cumulative greenhouse gases. Want to qualify it? I would submit no. There is nothing different in the scope of a federal power to regulate greenhouse gases simpliciter and to regulate cumulative greenhouse gases. The matters, the human activity that power could apply to are exactly the same. There's no dividing line. Because, as has been rightly noted, it all adds up. And, the fuel tax applies to one drop of, 1 liter of gas. And that liter of gas will produce however much carbon dioxide it produces, and that will have however much impact. And so where do we draw the line? If this head of power was recognized and Canada wanted to go further and enact more measures, because it was made clear the power is a permanent power, it's not just for this one act, they could impose all these additional measures as they see fit that could greatly regulate matters of land use planning, public works, industrial regulation, all matters that have always historically been provincial. And I can't say it better than was said in the anti-inflation reference, where they just went through the list of all those activities that would be governed by a plenary federal power over inflation, just as they would be by a federal plenary power over cumulative greenhouse gas emissions. It's because the sources of inflation, the sources of greenhouse gas emissions are so varied that the federal power would be so broad and so amorphous.
I find it challenging to you that we're really here, we're looking at the cause rather than the effect. Greenhouse gases are the cause of climate change. But what's really worrying the provinces and the federal government is climate change. We wouldn't be worried about greenhouse gases except for the smell if it wasn't for climate change. So if you called the matter climate change, would that make any difference?
That would make it worse. Because then that would make it worse. Because then even to the degree other causes, perhaps what matters could you take to require additional resiliency matters? If you go through the matters that Barrie Province are taking to encourage floods and climate, what matters are you taking to carbon capture or other mechanisms? All those would also be swept in.
So whatever you call it, assuming you're right, We have a national problem that affects all of us in very serious ways. And the thrust of your submission is that Parliament cannot deal with it. It's up to the provinces to try to get either do it individually or get their acts together and agree collectively.
So, first of all, I would submit that the case law is clear that important national problems are not necessarily matters of national concern in the constitutional sense. That's basically the holding of the inflation reference. Inflation was a huge national problem with a dramatic impact on people's lives, and the court found that it did not fall within the national concern doctrine. So too with the various Bennett deal legislation that unemployment insurance did not fall within federal jurisdiction. They had to amend the Constitution when it was decided to make it a single federal solution. But I would submit that that means that is the constitutional division of powers analysis. To address the other aspect of your question, Chief Justice, it does not mean Parliament is powerless, and it doesn't mean it doesn't have tools to encourage cooperation. First of all, it does still have its enumerated powers, which all have their internal limitations, and therefore pose less dangers to the constitutional balance than the broad, amorphous national concern doctrine that's really an exception to the usual rule. And so there are measures they can take. Part 3 of the Act, for example, the regulations about that's dealing with transportation and public lands and extra-provincial oil platforms and so on. The regulations they have that are true criminal law matters, such as prohibiting the use of certain fuels that are just too dirty to use in Canada. They also have the ability, both legislatively through the use of their spending power and through federal-provincial dialogue, to come to agreements, to encourage those national efforts. The provinces, the territories, and the federal government work together on hundreds of issues of critical importance to the Federation in a cooperative and collaborative manner. What is not needed in my submission is a federal ability to impose the one-size-fits-all solution, a carbon price or the highway. All other means of addressing the problem that may be more effective, may be more responsive to local concerns, they're just not good enough because they're not the way Parliament wants to do it. And that's that very caution that even Justice Ledane expressed in Crown-Zellerbach. There doesn't always need to be a plenary power in one level of government or the other. This is a complex problem that needs collaborative and cooperative solutions, not coercion of one level of government on the others.
If it were possible to come up with a verbal formulation that would capture a national carbon pricing scheme, such as we have here, if it were possible to come up with that and contain it, would you accept that that could be a matter of national concern? In other words,
Starts at So both securities references were dealt with under 91.2, the trade and commerce power, and in particular, the power, international or interprovincial trade. And that power has a similar risk to the national concern branch, which the court noted at paragraph 70 of the securities reference. On its face, the general trade and commerce power is broad, so broad that it has the potential to permit federal duplication and, in cases of conflict, evisceration of the provincial powers over large aspects of property and civil rights and local matters. This would upset the constitutional balance envisaged by sections 91 and 92 and undermine the federalism principle. To avoid this result, the trade and commerce power has been confined to matters that are genuinely national in scope and qualitatively distinct. That's where I got the reformulation I suggested to you, Chief Justice. From those falling under provincial heads of power relating to local matters and property and civil rights. In delineating the scope of that power, courts have been guided by fundamental underlying constitutional principles. The Canadian Federation rests on the organizing principle: the orders of government are coordinate, not subordinate to one another. Ottawa doesn't know best. That's not the presumption of our Constitution. As a consequence, a federal head of power cannot be given a scope that would eviscerate a provincial legislative competence. One of the principles underlies the Constitution. And to be fair, provincial heads of power cannot be given a scope that eviscerate federal enumerated powers. They have basic minimum content as well. That is not true of POG. There is no need to have any particular, there's no constitutional imperative to a basic minimum scope of the POG power. It is an exception, it's an add-on. Paragraph 73, they note the circumscribed scope of the general trade and commerce power, and I would submit even stronger, the circumscribed scope of the national concern doctrine, can also be linked to another facet of federalism: the recognition of the diversity and autonomy of provincial governments in developing their societies within their respective spheres of jurisdiction. As stated in the secession reference, the federal structure of our country also facilitates democratic participation by distributing power to the government thought to be most suited to achieving the particular societal objective having regard to this diversity. And I would submit, contrary to my friend's submissions, there is nothing wrong with different provinces taking different approaches that meet their unique local circumstances as they fight climate change.
The province does nothing.
Sorry?
But what about if a province does nothing?
So that's the point, is that the provinces should be free to decide what measures work best for them. And that they should be free to say a carbon tax is not the most effective measure. Ontario reduced its emissions.
Just do nothing. Forget the carbon tax. If we have a national problem and a province does nothing. Forget tax, of any measure.
First of all, I would submit that would not be a reasonable hypothetical. Every single province, and we've put this in the record, the plans are doing, every single province is taking action on climate change. Because quite frankly, they're responsible to their local electorate, and their local electorate demands that. Because it is a problem of importance to all Canadians. The point is, they take the measures that work for them. As I already pointed out, Ontario achieved a 22% reduction, already, we're trying to get to 30, we've already got 22%, without a carbon tax. Now, the federal government is upset that we're not doing more to make up some of the other provinces. But the point is, Ontario was able and is continuing to be able to take effective measures without putting a carbon tax on every drop of gas and every cubic meter of natural gas that ordinary Ontarians use to drive to their work and to their play and to heat their homes.
But you could have a province, I won't name one, but it's quite conceivable to have a province to say, look, our economic life, our economy is such that we're just not going to deal with this. The rest of the country can if it wants. Our economic development is more important to us than dealing with climate change. And under your solution, under your system, there'd be nothing anybody could do about that.
So there's a couple of points. Parliament would still have recourse to its enumerated powers within their proper spheres, not a broad power to do anything it wants. It would still have those powers. It would have the power to offer incentives through the use of the spending power to people in that province to take action they believe. I believe the Minister of Environment's already said she's going to be issuing incentives for electric vehicles. They could keep doing that. They could come to an agreement. They can put pressure on that because, as they do with every other important issue in our federation, education is dramatically important to our societies, and they're provincial. The federal government has influence through the taxing, through funding, but they're ultimately provincial, despite their critical importance to the future of our society. That's the norm in our federation. And that's why the detailed tests were developed to ensure the national concern branch does not overstep its proper bounds, does not allow the federal government to turn us into a unitary state. Essentially, at its heart, Justice Schreiber, your question is, in a unitary state, it'd be more efficient to have a one-size-fits-all solution. We make sure the problem gets solved because it's important to the state as a whole. That tension between national goals and local goals is the
Put against you, though, it isn't a choice between a one-size-fits-all solution and a variety of solutions. It's a choice of having a national solution or no solution, because without a national solution, individual province or provinces are free to do whatever they want in this area and to undermine the efforts of all the other provinces who may take action, as you say Ontario has.
But the power the federal government is claiming is not in any way limited to, okay, well, if you do absolutely nothing, not just climate pricing, if you do absolutely nothing, maybe, you just start lighting it all on fire, burn, baby, burn kind of things, then we can step in. They're not saying that little tiny backstop. That might be more akin.
Quantitative. If that's okay, that's also quantitative. That's not qualitative.
That's the point, that there's no dividing line. They're not saying.
So is a dividing line how much you do?
No, because it cannot be that the Parliament gets to rejudge the policy choices of the local electorate. That's not the point of division of powers. Is to say the provinces get to decide the matters that fall within their enumerated heads of power.
But when the actions of one province, a province doing nothing, impact another province, would there not be some basis for imposing a quantitative requirement?
No, because the problem is there still has to be something that can distinguish it, because otherwise that slippery slope is there again. And that's the exact...
Until it arrives to the level of an emergency.
Exactly. Like when you're in an emergency and a temporary solution to that emergency, that is a different case. But when we're talking about national concern, a permanent transfer of a head of power from the provincial to the federal governments, there does need to be something qualitatively different, because otherwise you're swamping the provincial jurisdiction. There's nothing left for the province. That's why in Crown-Zellerbach, the provincial inability criteria was not itself a step of the test. It was evidence of singleness, indivisibility. I can never remember the third criteria. It was an evidence of the first step of the test, but it was not the step of the test itself. And also, and this is the key point where I'm trying to get to, I think here, so Chief Justice, is that's the first step. Is the matter something we can distinguish? The second point is, even if we can distinguish it, would it be so broad, such an extension of federal jurisdiction, that it would unbalance the federation? And because of the nature of greenhouse gases and the nature of what the concern is here, I submit it fails both steps of the test. Even if, in the unreasonable hypothetical, as I would call it, that a province were to do nothing to combat climate change, not have a carbon price, but actually do nothing, which is not the case in any province or territory. The record in this case makes quite clear that every province and territory has a plan and is taking measures to combat climate change. Even then, that's evidence of, at most, the singleness and indivisibility. You still have the problem that giving the federal government the power over greenhouse gases that it would need in that circumstance would dramatically shift the balance of powers. And the way that is done as it was done with employment insurance, as it was done with old age security, as it was not done with inflation, is by a constitutional amendment, not by judicial interpretation of the national concern branch.
Can I give you an example of 4 different types of pollution in Ontario, and then ask you a question? Example number 1, asbestos. So asbestos pollution in lots and lots of buildings throughout Ontario. Number 2, garbage dumps. Really bad problem because of lack of tax dollars in the municipalities to clean up garbage dumps. So you've got an emerging large Ontario problem with polluting garbage dumps. Number 3, lakes and rivers in Ontario. Big problem with pollution, things being dumped into Ontario's lakes and rivers. And number 4, air pollution, greenhouse gases. Expect Ontario to be the government that tries to solve those 3 problems. But when you think about air pollution, the word Ontario sort of dissolves with the air. You're thinking, Ontario, yeah, but very quickly, Canada, and lo and behold, if you listen to the national news almost any day, international as well. So your first thought is not, when it comes to air pollution, caused by cars in Ontario, caused by factories in Ontario, yes, but your first thought is air pollution, you just can't solve it in Ontario. It's national and international. And surely the national dimensions test should accommodate that visual picture, visual difference between that and other categories of pollution.
Well, let me suggest a different visual picture that I would submit shows the problem with treating this as a matter of national concern. The causes of pollution in Ontario. The local factory run by a small businessman employing thousands of Ontarians, trying to produce a product in a heavily trade-sensitive matter where competitors may not have concerns. The local family driving to work, having to get their kids to school and to activities. The municipality trying to decide how best to allocate land between various uses in ways that protect the environment and also encourage growth and development in Ontario. The provincial government and its various bodies deciding where to build hospitals and schools and how to build them, what materials to use, what building codes to follow, managing its natural resources, where to allow timber extraction, where to allow petroleum extraction, and what processes to allow in those. Those are all matters that I wouldn't say aren't just mentally provincial. They're listed in the Constitution. Those are provincial matters, and all of them would be subject to federal regulation if my friend's submission were accepted, because they all have an impact on greenhouse gases. And yes, we all have to work together to solve this problem, and Ontario has been and is continuing to do so, as are all the other provinces and territories, as is the federal government. And we should work together collaboratively in our respective spheres of jurisdiction to do so. The federal government, the Lakes and Rivers example, to the degree it's infecting fisheries and navigation, the federal government has a role to play. Outside the boundaries of the provinces, they have a role to play. Interprovincial undertakings, they have a role to play. But what I submit they do not have a role to play, and they go too far in passing this act, is trying to determine the cost of the basic inputs to every single human activity in this province, which is what this scope of power, this head of power would allow them to do. And that is why the distinction was drawn in these 2 cases in the securities reference. The argument was made in the securities reference that no, we need to have a national regulator. Everyone else has one. It's securities in this day and age. It's not just, the local companies selling their shares to local investors. It's a global, transnational world where all the risks affect everyone. And this was right at the era of the global financial crisis. So it was brought home what a matter of national and international importance it was. And the Supreme Court said no. The provinces have a role to play. The provinces cooperate, even though regulators were saying exactly the same kinds of things about, well, why do I have to comply with 13 different security regimes? What if one province says no and I have to deal with, jumps through extra hoops there that are just there to protect their local investors and aren't really keeping in mind the national flow of funds? And the Supreme Court said, no, that is the proper role of the provinces. It did leave things for the federal government. The idea of national systemic risk, which was upheld in the cooperative scheme that was approved in the Pan-Canadian Securities Reference, where the provinces and the federal government worked together to delegate their powers to a proposed regulator. And there's just been some discussion about what systemic risk is. I just thought it might be helpful to just briefly discuss what that concept is and why, in my submission, it's completely different than cumulative risk or cumulative greenhouse. And so I put in an article in the Georgetown Law Journal, which is at the last tab. Stephen Schwartz, a US author. It's tab 49. And this was referred to by the Akabuchi report that was later referred to repeatedly in the court as the definition of systemic risk. And so the distinguishing factor, starting at page 198, is that a common factor is that a trigger event, such as an economic shock or institutional failure, creates a chain of bad economic consequences, sometimes referred to as a domino effect. And then the classic example over the page at 199 is a bank run. The idea being that it's not just I lose my account because the bank doesn't have the money to pay me. It's the idea that because of the nature, the bank doesn't actually have enough cash on hand to satisfy everyone's deposits if they all come at once. And as soon as you have a panic, everyone comes running to the bank and it can't meet its obligations and has to close. The more modern version, which the author goes to in quite a bit of detail, is risk to the market itself. And that's what we saw in the global financial crisis. Things like the financial intermediaries that provide the necessary liquidity to the whole system to keep the machinery of commerce greased and the wheels of the economy moving. If they go down, it's not just, Royal Bank goes down and people who are Royal Bank shareholders and people who are Royal Bank direct customers, they lose their money. It's, oh no, a giant piece of the financial system has gone down and there's not the liquidity necessary, so everything comes tumbling down. It's not just a linear addition of A plus B plus C. It's an exponential that has an impact far beyond its concerns. Turning to trying to draw an analogy to greenhouse gases, my friends are saying it's the cumulative effects because you can't distinguish Ontario's A and Saskatchewan's B and British Columbia's C and China's D and the United States E. But the impact is the global amount. It's linear. It's the amount you add up, the total amount of emissions and the impact that has on global warming. It's not a case where there's something different about it. It's just our emissions and their emissions and their emissions and their emissions, and you all them all together, and how much is it? And that's why when you look at, well, what would a power over cumulative greenhouse gas emissions allow you to regulate? There's no stop. In the securities context, there was a stop. Sales broker and what their qualifications were. You can only regulate the issues that actually have this different systemic issue, that they can impact the market itself, not just market participants. There was somewhere to draw the line, and that's where the court drew the line. They said, securities reference, no. Pan-Canadian securities reference, yes, because you've achieved a qualitative difference.
Part of the problem, just going back to cause and effect, is that the cause in some Canadian jurisdictions is a very small contribution to the overall greenhouse gases in the atmosphere. So take the Yukon as an example. There are profound effects of greenhouse gases in Yukon, but their contribution to greenhouse gases is minimal. And yet nothing they do in relation to greenhouse gases is going to impact the effects that they're feeling. Isn't that an area, doesn't that indicate both the the national nature of the problem and the singleness, distinctiveness, and indivisibility of it?
Well, on the first branch of the test, it is evidence, but is it enough evidence to show that this is something qualitatively different? Because the problem is, you still have the problem of the provinces that are going to be impacted by forced change things, they are not able to, there's no limit to what can be controlled. So what you could say is that no one in Ontario can drive a car because there's an impact on the Yukon. Now, I'm not saying the federal government would go to that draconian amendment, but that's what the power would allow. There has to be a $1,000 tax on every new development on greenfield land because it's going to impact climate change. So the effects of the scope of the power still don't have any delineation. And so that's why, is there a problem that needs to be solved? Yes. Is the tool to solve that the federal government be given a plenary power outside the enumerated groups of heads of power to allow it to do as it sees fit without even having to cooperate with the provinces? No. I would submit the proper solution, and which is the one we adopt again and again in this country, is that we have to work together.
Well, that didn't work, though. I mean, isn't that part of the problem? That there was an effort to cooperate, to have carbon pricing across the country, and there seemed to be a certain consensus that that was the way to go, and then it didn't work for obvious reasons.
But that is, again, confusing the tool and the cause. The national problem is greenhouse gas emissions. The solution has to be to find a solution to greenhouse gas emissions and climate change. That solution does not have to be a carbon tax. And that's the same as insecurities. The national problem was there's no certainty, there's no common set of rules. It creates a whole bunch of impediments for national investors, and those investors could have exactly the same kind of impact. So for example, pick a province, let's say a small province, let's say PI, and they have no ability to, let's face it, most large companies are going to predominantly comply with the rules of the larger provinces. In New York and Ontario and London, right? They're going to worry about the big regulators. It had no power to require the national rules to meet its needs. And the Supreme Court said that's a matter for the provinces to work together and cooperate on. They did not, as was requested, give the federal government the power to impose a single uniform set of rules on all the provinces. That's exactly what Alberta and Quebec took the federal government to court to stop, because they wanted to have their own unique local solutions. And the federal government said, no, we know best. We need the national solution. It's exactly the same here. The federal government has a role to play, but its role is not making all the decisions, deciding which tool is best. That can and should be left to the individual provinces.
That would be absent an emergency.
That's obviously a separate head of power. At this point, I'm only talking about the national concern power. And as I say, I plan to address some of the enumerated heads of power and the emergency power that my friends raised, but happy to get into them now, but I would submit it's more appropriate for reply as they are not heads of power being relied on by Canada. So that is my submission why the national concern branch should not be used to give a plenary power over, call it what you will, cumulative greenhouse gases, greenhouse gas pricing, whatever you call it. There's no definition that can provide that necessary dividing line. The definition put forward by Canada and the definition suggested by the interveners do not set out a single, distinct, and indivisible head of matter that's qualitatively different from provincial enumerated powers. And even if they did, they would represent a massive shifting of the division of powers between the provincial and federal layers of government, and that massive a change should only be made through a constitutional amendment for which provincial consent is required. It should not be made unilaterally by federal submissions about the scope of the national concern branch. Last few minutes before I turn things over to Mr. Ryan, I'd like to deal briefly with the first step of the test, the characterization of the Act itself, and its relation to the claimed head of federal power. And my submissions on this point are quite brief. But in a nutshell, it's the act is not to the cumulative aspects. If I'm wrong, and there in fact is a dividing line between local, intra-provincial greenhouse gas emissions and cumulative greenhouse gas emissions, as my friends suggest, then the act those federal matters. But on its face, it's not. Part 2, which is the more limited of the two sections, applies to any covered facility that the federal government prescribes by regulation. Now, to be fair, there is a minimum CO2 equivalent emission in the current regs. That's in the regulations, not in the Act itself. The Act imposes no such requirement. They could list every facility in Canada if they so chose. And they do have the discretion to list any facility under 172. So there's no limit to facilities that are large enough to impact the cumulative dimensions in a significant way. That division is even more egregious in the case of Part 1. Part 1 imposes a fuel charge that is based solely on a volumetric basis. It's on every last drop of gas, every last cubic meter of natural gas distributed, imported, sold, et cetera, in this country, in the listed provinces. So even one liter of gas, 1 cubic meter of natural gas, you just need to fill up your propane tank to have your barbecue in a provincial park. That's going to be subject to the tax, even though it has an infinitesimal impact on Canada's greenhouse gas reductions, which are themselves only 2% of global greenhouse gas reductions. So to the degree that the cumulative impact is the dividing line, the Federal Act has not been carefully tailored to limit itself to those cumulative aspects. And that was exactly the reason why the Supreme Court in the two securities references said Act 1 was unconstitutional, Act 2 is constitutional. The first act regulated all aspects of the securities market in Canada, ultra-virus. The second act limited itself to those matters that were uniquely federal, and then provincial governments could delegate. I should note also that those provincial governments, the court was also very clear that the provincial cooperation was not a for all time. There was always the possibility of provincial government could change its mind, as required by the fact that you can't fetter the legislature. And that wasn't a problem. So whatever the provincial inability test does mean, it doesn't mean provinces can never change their minds and take different policy choices. But this act does not limit itself to those narrow matters. It is a broad base, and by design, I don't think my friends will disagree with that by design, it covers everything. That's the whole point of it, is it wants to say this is the way that this problem has to be fought. No other solution is permissible, so do it our way or else. And that, I would submit, even if cumulative greenhouse gases are a proper matter for federal regulation, which I say they are not, means this act goes beyond even the broad amorphous scope of that power and should be declared unconstitutional by this court.
Your characterization step is a very brief one, as it always is in the cases like Crown, Zellerbach, and anti-inflation. It's at paragraph 53 of your factum. It's a single sentence. The act must therefore be seen as in pith and substance, and here it is, your characterization, an attempt to create a comprehensive regulatory scheme for the reduction of greenhouse gas emissions from all sources in Canada. One way of reading that is there's not a word there that even hints at anything provincial, and yet that's your description of the act. It's comprehensive regulatory scheme, it's greenhouse gas emissions, it's all sources, and it's in Canada. That doesn't sound provincial. None of that sounds provincial.
Well, no, the whole point is every single one of those matters are matters that are provincial. And as the court warned...
But when you put them together, and it's air pollution, are they really provincial?
That was the exact point the court warned against in inflation. Justice Lafraye's dissenting Crown Zellerbach, that subsequently the ruling of the majority. You can't just add it up and say, look, this is a problem, and this is a problem, and this is a problem, and put them all together, and now it's a national problem. And as they said in Scripture, the aggregate of industries being regulated does not make a matter of national concern make. So what you have to look at, and it makes it quite, the preamble of the act makes it quite clear, they do intend to regulate all greenhouse gases. What is the impact of that? What is the effect, to put it in pith and substance terms? The effect is that you're regulating local industry, local land use, local heating, all the matters that are inherently the matters that have always been within provincial regulation. Look at it in the case of, to give some examples of other matters of national concern that are rejected. In the employment insurance context, they try to say, no, we're regulating employment insurance. It's a new thing. And the court said, no. You're regulating contracts of insurance and terms of labor. Those are provincial. And the fact that you want to do it for the whole country because we're in a depression and we have a huge crisis and we have all these millions of people out of work wandering the country looking for work, that does not make it national concern. In the 70s, when inflation is going 15, 20% and people are losing their homes and not sure of their jobs, and the federal government says, look, we need national price and wage controls. And the government says, that once again, the court says that's not national concern. Now, they did say it was an emergency because those were temporary measures. Nothing in this act is intended to be temporary, and I'll come back to that in reply to my friend's submissions when they deal with, the interveners deal with emergency power. This is an act that says this is the one way to fight this problem. Any other way of fighting this problem is not good enough, and do it our way or else pay. And I would submit that, first of all, the matter that is claimed is so broad, it is not single and distinct, and it would fundamentally alter the balance of our federation, and taking power, as said by Justice Betts and Justice Lafreye, would make the division of powers nugatory. Can't really speak of the division of powers when the federal government can regulate everything. And I submit that is not a decision this court should make, and that act should be declared unconstitutional.
I think with that, we'll rise until 2:30. Thank you.
Order. Order.
The court resumes. Please be seated.
Mr. Ryan.
Thank you, Chief Justice. This afternoon, I will be providing 2 additional submissions from Ontario. First, that the Act does not impose valid taxes because, first, the pith and substance of the Act is that of a regulatory scheme which cannot fall under the federal taxing power in Section 91, Sub 3. And second, because there was no express and unambiguous authorization of a tax as required by Section 53 of the Constitution Act 1867. Secondly, that the charges imposed by the Act are unconstitutional because they do not meet the legal criteria for valid regulatory charges, also under Section 53 of the Act 1867. You through this morning in Buff, and I'll also ask you to have the first volume of the Joint Book of Authorities nearby. I'll start off by saying a brief word about how those two submissions fit together, because you will hear me saying at some points that in our view the charges imposed under the Act are unconstitutional taxes, and at other points I'll be arguing that they are also not valid taxes, which obviously both involves calling them taxes. But this is because our submissions address both the primary and alternative arguments being advanced by Canada in this reference. Canada's primary position is that the Act is regulatory and it's as permitted under POG, under the preamble to Section 91, and that the charges that it imposes are valid regulatory charges. Its alternative argument is that the Act is a taxing statute under 91 sub 3. And once the court goes through the classification exercise under Section 91, obviously, if you accept Ontario's arguments, the under either and there's simply nothing more to be said. But if you determine that the Act falls either under POG in the preamble or the taxing power in 91.3, there's a second test to be applied under Section 53, which depends upon that characterization. If the Act is found valid under POG, go later in my argument. On the other hand, if the Act is valid under the taxing power in 91 sub 3, then Section 53 requires that the court ask whether the taxes have been authorized expressly and unambiguously. And that's the test which comes from the Ontario English Catholic Teachers Association or the Confédération des Syndicats Nationaux case, which I'll be referring to as CSN. And that's simply examination of whether Parliament expressly authorized the tax. And so I have to address both heads of the Section 53 argument because we're facing arguments on both fronts from Canada. An example of where the court went through a similar exercise of considering first veeries under Section 91 and then moving on to consider Section 53 afterwards comes from the CSN case, which we have not included in our compendium, but which is at tab 17 of the BOA volume I had you pull up. And in that case, similarly to this case, the Attorney General of Canada, in defending certain provisions of the Employment Insurance Act, had a primary argument that the Act was valid under a regulatory power, the employment insurance power, and the attorney had a secondary argument that in the alternative it was a tax under 91 sub 3. And in fact, the court split its decision where for some provisions it accepted that they were valid as under the regulatory power, but for others it concluded that they were meant to impose taxation under 91 sub 3. So it accepted the Attorney General of Canada's alternative argument on veeries under Section 91. It then went on, however, to consider whether the requirement under Section 53 had been complied with. And it ultimately concluded that it had not and held the provisions unconstitutional on that. Which simply means that surviving the classification exercise at Section 91 isn't sufficient no matter which of the arguments you accept from the Attorney General of Canada, and something more has to be done under Section 53 as well. To start with validity as to the taxing power, Ontario agrees with Canada that the federal taxing power under subsection 91.3 is broad. It cannot, however, be limitless, or the pith and substance classification exercise under section 91 would be rendered essentially redundant. The pith and substance exercise is concerned with the actual matter being dealt with by the impugned legislation. If the standard for the taxing power, unlike other powers, was set so low that any statute which involves the low threshold of a monetary payment to the government, that allows any statute with that feature to be held valid under section 91 sub 3, it would render this process meaningless. Instead, the court needs to look at what is the actual matter being regulated. An example from the case law that we have of this approach, specifically under the taxing power, comes from the employment insurance reference, which is at tab 23 of the compendium. And this dealt with a federal employment insurance program, which was passed in advance of the constitutional amendment, which Mr. Hunter referred to this morning. It dealt with a federal statute which involved payments from employers and employees and payouts under specified circumstances related to the unemployment of employees, very much like the EI scheme we ultimately have once that constitutional amendment was passed. Before that amendment, though, the majority of the Supreme Court had held it unconstitutional as being concerned with insurance, which was a provincial matter under property and civil rights. And two judges on the Supreme Court of Canada had held that the act was valid under the federal head of power over taxation and public property. And they pointed out, much like the Attorney General of Canada points out in this reference, that the act involved collecting payments on the one hand and paying them out on the other under certain criteria set by statute. And according to those two judges, that was enough for a federal scheme to be salvaged under the taxation and public property powers held together. The act of taking the money is taxation, and then once it's in the government's hands, it becomes public property, which can be spent according to that head of power. The Privy Council did not agree. In the decision which we have excerpted here, it determined that what was really going on here was an insurance scheme. The mere indication money being collected by the government wasn't sufficient to classify it under 91 sub 3. It by no means follows that any legislation which disposes of it is necessarily within Dominion competence. It may still be legislation affecting the classes of subjects enumerated in Section 92, and if so, it would be ultra vires. In other words, Dominion legislation, even though it deals with Dominion property, reserved to provincial competence. It is not necessary that it should be a colorable device or a pretense. Or in respect of other classes of subjects otherwise encroaches upon the provincial field, the legislation will be invalid. To hold otherwise would afford the Dominion an easy passage into the provincial domain. We say the same analysis applies to Canada's argument in the alternative that the federal act at issue in this reference is an exercise of 91 sub 3. In the same way, the court has to look at what is the true matter being regulated. And here we have the benefit of all the arguments in Canada's factum under its primary argument as to why the pith and substance of the Act is in fact a regulatory scheme for greenhouse gas emissions, which is concerned entirely with behavior modification and not with the raising of revenue, which is the broad but not limitless power exercised under subsection 91(3). The Act's preamble, which is together with the statute in our factum at tab 2, I will not read out because it's 2 pages long, but suffice to say there is no reference in this very detailed and clearly, carefully thought out preamble to the raising of revenue for general purposes, which makes complete sense given that the federal primary argument is that this is a regulatory scheme under POG, and this preamble is consistent with that. There's reference to behavior modification, increased energy efficiency, the pricing of greenhouse gas emissions, the polluter pays principle, greenhouse gas emissions pricing systems. These are all indicators that the pith and substance of the legislation cannot be said to be taxation.
Your friend kept calling it the carbon tax. Your colleague, Mr. Hunter, repeatedly called it the carbon tax. So Ontario's position is this is not a tax?
In several of the cases that we have relied on our factum, where a purported regulatory charge fails the relevant legal criteria under Section 53, the Supreme Court has called that an unconstitutional tax. So Ontario's position is that the charge is a tax in that sense, in that there's no connection between the regulatory charge and how the funds are spent. But we say that's not the same analysis as ought to be performed under Section 91 for validity purposes. Otherwise, it's simply too easy for the federal government to always have that fallback available, even when they proceed with a clear intention to pass the act under some other head of power, a regulatory head of power. And in particular, as I'll get to in the Section 53 portion of my argument, the requirement to seek the express and unambiguous Parliament acts makes it very difficult for a government to have it both ways in the legislature, to, in defending their scheme, say it is and is not a tax, because that by definition will not be unambiguous. It sounds very ambiguous. In addition to the preamble, there's also the particular regulatory character of Part 2 of the Act, which I won't have you turn up because Mr. that are in that part which apply to all covered industrial facilities which emit a certain threshold. It includes detailed reporting requirements on GHG emissions to Environment Canada, not to the Canada Revenue Agency, which is the agency tasked with administering Part 1. Emissions limit is set based on the output of these facilities by the governor and council. In particular, there's the surplus credits option where a facility over-complies in 1 year, it will receive credits from the federal government, which it can use to make up for under-complying in a future year, which sounds very regulatory in character, not something that we would see in a taxation scheme. The Act contemplates the transfer of compliance units between different facilities so that an over-compliant facility can trade credits to an under-compliant facility within the same year. Again, perfectly consistent with the behavioral change purpose which we see in the Act's preamble and advanced under my friend's primary argument, but something that does not look much like taxation. The governor and council may establish a system for granting offset credits to those operators of the covered facilities who create a completely separate project which has the effect of reducing greenhouse gases. These are all features which are consistent with Canada's primary argument that this Act has a regulatory character, which we say are fundamentally incompatible with its alternative argument that the Act is valid under 91 sub 3. That '53, which provides a very important separate constitutional requirement on both federal and provincial laws alike, that they not only be valid under the division of powers, but that they comply with this section, which the Supreme Court has interpreted as the codification of the constitutional guarantee of no taxation without representation. As the Supreme Court explains in the Connaught decision, and its purpose is to ensure parliamentary control over and accountability for taxation. So on a pure textual basis, it can't be sufficient for a federal act to be classified under Section 91 sub 3, because this is an additional requirement in the text of the Constitution Act 1867, which applies to the exercise of the taxing power. The levying of taxes unambiguously authorized by Parliament. And that's the phrase used by the Supreme Court repeatedly in the Uric decision, in the Oecta decision, and in the CSN decision. And what this means is that if the nature of the levy remains ambiguous or unclear, the court is not satisfied that there's a clear authorization of a charge that is in substance a tax, that tax is unconstitutional. And as an example, I'll ask you to turn up the CSN decision, which is at tab 17 of the joint book, volume 1. And I'll ask you to turn to paragraph 93. This is where the court, at this stage in the decision, has found that certain amendments to the EI Act, which allowed for premium setting in some years to be completely divorced from a regulatory purpose, from a cost recovery purpose, amounted to taxation. And then it had moved on to the question under Section 53, whether Parliament had authorized that taxation. The relevant provisions of the Employment Insurance Act must therefore be examined to determine whether, as an Ontario English Catholic Teachers Association, they are consistent with the principles laid down in this court's decisions. The provisions in question do not state that Parliament is delegating taxing authority to the Governor General and Council. The nature of the levy remains ambiguous. It is unclear whether Parliament still considered that it was exercising the authority to impose a regulatory charge in enacting those provisions. At the time, Parliament delegated the power to collect employment insurance premiums to the Commission and the Governor General and Council. The legislation contained no statement either that its purpose was to collect a tax or that Parliament's taxing authority was being delegated to the Governor General and Council. The delegation concerned a charge that was no longer a levy for specific purposes, but had become a levy for general purposes within the meaning of West Bank. But it was not specified in the Act that Parliament intended to delegate its taxing authority as such. Parliament would have had to state that it was delegating that authority to the Governor General and Council. Owing to the ambiguous nature of the levy, whether Parliament intended to delegate its taxing authority remained uncertain. And that was enough for the court to ultimately conclude that the provisions were unconstitutional. Ontario's position is that the same is true of the charges collected under this Act. And in fact, many of the features which were lacking in the Employment Insurance Act in the passage I just read you are also lacking in the Federal Act. In our view, the Act is not merely unclear or ambiguous as to whether Parliament authorized taxation. Instead, there are several strong indicators of specific parliamentary intent to not authorize a tax. First, as we just discussed, there's the preamble to the Act and its predominantly regulatory character, which, although is chiefly relevant to the classification exercise under Section 91.3, is also difficult to characterize as compatible with an express parliamentary view that this Act was intended to authorize taxation. Second, there's a textual indicator that the Act was not intended to impose taxes, and that comes from comparing the Act, which was Part 5 of a Budget Implementation Act, to the other legislation that was before Parliament at the same time. So if you turn up tab 1 of our compendium, over the page is the table of provisions for the 5 parts that made up the bill, which was before Parliament, which is now consolidated together as Chapter 12 of the Statutes of Canada 2018. Part 5 at the bottom is the Greenhouse Gas Pollution Pricing Act, and a quick glance shows that Parts 1, 2, and 3 all involve use of the express phrase tax. They're amendments to existing legislation, but they do in some cases impose or increase taxes. And we say it's one thing to consider whether Parliament intended a tax on a statute that doesn't use the magic word tax, but stands on its own. And then the court can go through statutory interpretation. But we say here the use of different language in different parts of this bill, charge, as used in the GGPPA, had a distinct meaning from tax, as used in parts 1, 2, and 3. And that's just a basic principle of statutory interpretation, as set out in Sullivan's textbook, which is cited in our factum, that there's a principle that Parliament is presumed to use the same phrase consistently across legislation, a single piece of legislation, and conversely, when it uses a different phrase, it must have a different meaning. So that is a textual indication that is incompatible with a theory that Parliament expressly and unambiguously authorized a tax in this case. We also have the benefit of an explicit discussion in the House of the question of whether the Act imposed taxes, which is an excerpt from Hansard at tab 21 of our compendium. And here it is put to the parliamentary secretary, to the Minister of Finance, who is the sponsoring minister for a budget and implementation bill, the accusation that the law authorizes taxes. And specifically, the opposition member says the tax goes to the finance minister. And presumably that's one of the reasons why the parliamentary secretary was responded. And he expressly denies that the government sees this bill as a tax. Here is where I disagree with my esteemed colleague. We see this as a price on carbon pollution. My colleague calls it a tax, but it is actually a price on carbon pollution. So taking these 3 elements together, first, the regulatory character of the Act and its preamble concerned with behavior modification, making no mention of the raising of revenue. Second, the use of taxation as an explicit term elsewhere in the bill. And third, an express statement to the House from a member of the executive that the bill was not intended to impose taxation, Taking all three of those things together, Ontario says the high threshold set by Section 53 has not been met. I'll now turn to Canada's primary argument on Section 53, which, as I said earlier, is that there's no requirement under Section 53 to authorize taxes in this case, because in fact, what it imposes are regulatory charges. Ontario's position in response to that primary argument is that because there is not a sufficient nexus between these charges and the Act's regulatory scheme, the legal requirement for a valid regulatory charge is not met. And in particular, the funds raised by these charges are not
Argument, if they're not taxes, what are they?
They are what's sometimes called by the Supreme Court unconstitutional taxes.
Taxes under 91.3, and even if they are, they don't meet the requirements of Section 53. So you're saying they're not in any way, shape, or form taxes, so they have to be something, and you're characterizing the legislation as a form of unconstitutional regulation. So doesn't that necessarily follow that they're regulatory charges, in your view, unconstitutional ones, but regulatory charges?
What we have in Section 53 is a specific requirement that taxes be explicitly authorized. And a way that a government can run afoul of that is either by passing something which is in substance a tax, but not seeking the proper approval, which is the argument that I just walked through, or by passing something which purports to be a regulatory charge. So there's also no express or unambiguous authorization, but which does not meet the criteria set out by the Supreme Court for a valid regulatory charge. So, and classification under Section 91 doesn't answer this question. So in Connaught, the federal government defended a fee in that case as a valid regulatory charge.
So just, make sure, so is this a second argument that if this were a valid exercise, even if it were, the charges are not, because they're not sufficiently connected to an otherwise constitutional power?
That's right.
So this argument, if this were permitted as under the national concern clause, you're challenging it on the secondary basis that the charge itself doesn't meet the requirements.
That's right.
Okay.
The options for a government under Section 53 are either to levy a charge which is not a tax, or to proceed with something that is a tax, but seek express authorization for it. So what I was just referring to earlier was the second branch, that there's no express authorization here. So even if it is a valid tax under Section 91, it's still unconstitutional under Section 53. And what I'm addressing now is the federal government's primary argument that this is not a tax, that there's Section 53 is not engaged, that this is under the preamble to Section 91 and not 91.3. And there are certain legal rules as to what constitutes a regulatory charge, which we say are not met here. So under either of those arguments, it's always open to a government subject to other constitutional constraints to expressly pass a tax, but that's not what occurred here under either argument.
Why isn't rewarding everybody in Ontario with money for participating in a successful emission reduction program a wonderful nexus?
I don't think it's accurate to characterize it as a reward, because you receive the payment regardless of your actions.
No, but you receive the payments because Ontario has complied with the Act And because Ontario has complied with the Act, people have been paying taxes at the gas pumps all year long. The result of that is the people of Ontario get money back in their tax returns, real money. That's a reward to the people of Ontario for helping Ontario comply with the Act. That strikes me as about as tight a nexus as you could imagine.
In Ontario's view, a refundable tax credit, which is paid out simply by virtue of being a person who exists in the jurisdiction at the time of the tax credit, is the quintessential example of spending on. There's not, the only nexus is that they apply to the same jurisdictions, which would completely eviscerate the rule under Section 53 if any charge could be levied above cost recovery simply because we are all subject to the same laws now in Ontario. So as an example of the type of behavioral charges that we're thinking of, Ontario could pass a law saying we want to deter an unhealthy behavior. This is the new price that we are setting for it, and we are going to use the revenues raised from that behavioral charge to fund the general treasury. There's no specific scheme. Simply, we're reducing the need for other taxes by raising money from this charge. And if that's all that was required for a nexus, that it be the people in Ontario are subject to that law, then it would be met. Which, in the cases that I'd like to take you through, we see a much higher standard for nexus between the person paying the charge and the regulatory scheme. And in particular, in the Connaught case, the Supreme Court expressly declined to decide the question of exactly this, of whether a charge which is levied for the purpose of affecting behavior, whether the funds that it raises can go above the cost of the regulatory scheme and can be used as they are here effectively for general revenues. Ontario submits that that question left open in Connaught should be answered in the negative. Instead, the court should establish a rule that does not allow governments to circumvent the important constitutional restraints in taxation, by attaching a behavioral purpose to a charge which raises funds for general purposes. If that low threshold were sufficient to avoid classification as a tax, any number of such charges could be used by a government, whether federal or provincial, in order to deter any number of behaviors, to fund its entire operations from such charges, and to permanently evade the requirement in Section 53 that a tax be authorized by the legislature as a tax.
Isn't the way this scheme works, or the idea behind it, that the person who uses products that cause greenhouse gases is to internalize, so that they bear the cost, and to internalize the cost incurred by using these fuels? Isn't that the regulatory scheme? It's not so much deter behavior. Just saying, if you use this stuff, you're going to pay. You're going to have to bear the cost that this inflicts upon the rest of the world. Isn't that the way the regulatory purpose of this statute works?
Ontario agrees that that is a perfectly valid regulatory purpose for purposes of Section 53, setting aside our other concerns. Mm-hmm. The question is there also a limitation on what use can be made of the funds? So does the fact that a behavioral charge has the purpose of affecting behavior, does that give the government a blank check to use the funds that it raises for any purpose that it wants?
They don't have a blank check. The sections that we were referred to says they must distribute the money either to the province or to the residents of the province. So the government doesn't get the money under the statute.
So my first answer to that is that my friends aren't relying on that feature to defend this as a valid regulatory charge. They rely on the paragraph from West Bank, which says something very similar to what you just said, that a regulatory purpose is sufficient, and they say, and we are entitled to use the funds for whatever we want. So if that were your holding, that the payout section of the Act is what makes it a regulatory charge, That would be less than what's being sought here. More importantly, I think in the example of Connaught, we have a scheme where the legislation provided for the raising of the revenue and the spending of it together, where there was clear, at least textual statutory authority for that kind of scheme. So it did the same thing that this act does. It raised revenue on one side and it spent it on the other. And if it were normal, instead, what the court did is inquire into whether there was sufficient nexus between how the funds were raised and how they were spent within that scheme. So I'll ask you to turn up the full version of Connaught, which is at volume 1 of the Book of Authorities.
Volume, sorry?
Volume 1 of the Joint Book of Authorities, tab 1. So at the end of paragraph 1, the court quotes the fee-raising authority. The minister is authorized to fix the fees or the manner of calculating fees in respect of products, rights, or privileges provided by the agency. And then if we jump ahead to section 11, paragraph 11, the quote quotes a different provision, which says that the Parks Agency is authorized to expend those revenues arising from fees paid under any act of Parliament. So as I said, if this is a normal administrative law statutory authority case, the Parks Agency would have a very strong defense that it had been authorized, the raising had been authorized, and the spending had been authorized. With the court's inquiry into the validity of these regulatory charges was much more nuanced than that. And in particular, both of those provisions which I just read to you applied to the entire national park system. But the court made clear that the reason that the fee in question was upheld, which dealt with Jasper National Park, was because the fees were spent within the park itself. And in particular, at paragraph 45, the court says, there must be a relevant relationship at the second step, that is, between the fees paid by the persons being regulated and the regulatory scheme caused by the persons or from which those persons receive a benefit. And those conditions were met in this case. However, I would note that if the fee revenues generated in Jasper National Park are not expended entirely within or for the benefit of that park, the fees may well be unconnected and not in pith and substance a regulatory charge, but rather a tax. So that amount, such a fee, so if Jasper National Park runs on a profit, so to speak, and that profit is used to operate Point Pelee National Park, that would amount to taxation in the Supreme Court's view, despite the fact that the statutory scheme as a whole was in one sense revenue neutral. The fees were still being directed, were clearly directed under the spending provision to be spent on maintaining national parks. But the Supreme Court said the nexus requirement is stricter than that.
Do you have, I'm trying to make sure I'm in argument again. This case is about, is it a regulatory charge or is it a tax? And Canada, I think, puts to you in response to your arguments that, well, if it's not one, it's the other. And you seem to be saying that there are two different tests, that even if you still have to have a regulatory charge if it's under the national concern. You're taking it into a context of not just is it a tax or a regulatory charge. Do any of the cases that you have deal with whether it's a regulatory charge other than trying to decide which it is, a regulatory charge or a tax?
So we are in agreement with Canada that it has to be one or the other. It has to be a regulatory charge or a tax.
Right.
The difference is that if it's a tax, there's a requirement of express and unambiguous authorization.
Understand that.
Which we say is lacking.
Right.
So in response to that argument, Canada can either say there is...
So you're making this argument just to set up the requirement for Section 53.
That's right. So if a charge fails the requirement to meet a valid regulatory charge, then it has to be authorized as a tax, which we say isn't met here. So we didn't have this complication in Connaught because it doesn't appear that the federal government had an alternative defense that the tax had been authorized.
But your primary argument is that it is not a tax.
Canada's primary argument is that it is not a tax.
Ontario's primary argument is it is a tax?
Our argument is that under Section 91,
Yes.
it is not a valid exercise of the taxing power
So
under
it's
91
not,
sub 3.
so this is a subordinate argument. Your primary argument is that it is not a tax under Section 91. Therefore, if it's not a tax, there has to be a regulatory charge.
It has to meet the valid criteria for a regulatory charge, and if it does not, it is unconstitutional.
But see, I thought the cases are it's one or the other.
It's one or the other, but one of them has to be authorized. And we're just having two different debates with my friends. So one is, what is the character?
So is it, if it has to be a tax or a charge, what does Ontario say it is?
Our primary position is that it is an unconstitutional tax in violation of Section 53 because it does not meet the criteria for a regulatory charge, which responds to Canada's position that what they are acting under is POG. A tax is not available under POG, under the preamble to Section 91.
Can you just repeat that again? Your primary position is that it is,
Our primary position under Section 53,
but just, is it a tax or a regulatory charge? Which is it?
we say it is a tax which has not been authorized. That is Ontario's primary argument under
Okay,
Section
so,
53.
so you're saying it's a tax, but that doesn't meet the requirement of Section 53, not that it's not a tax under 91.3.
I think that's correct.
Okay.
What we're saying is that by having a purported regulatory charge under Section 53 and failing that legal test that the Supreme Court set out in Connaught should not in itself be enough to establish validity under Section 91. It cannot be that a statute which has a predominantly regulatory character, which is described to the House as not being a tax, but which fails the criteria for properly acting in a regulatory character, receives the benefit of being classified as a valid tax under Section 91.
But in order to succeed on that argument, your position, as I hear it is, what's wrong is that the federal government has decided to take the money it raises and give it back to two things. One, individual Ontario people, or, that's 90%, or two, 10%, Ontario institutions. And you're saying no. The federal government can't give the money back to Ontario people or institutions. They must give it to what? Federal institutions?
Justice McPherson, we are not in any way saying they cannot do it.
Well,
You're
you're saying it's invalid. If that's what, I mean, that's what they've done here, and you're saying the regulation here doesn't work. They can't give it to those two people. There's only two recipients of the money from this legislation. One is Ontario people, 90%, and the other is Ontario institutions, 10%. That's it. And you're saying that's wrong. It's not legal.
We are saying raising revenue and spending it for what our purpose from a regulatory scheme is taxation, which the federal government, like any other government, is perfectly entitled to do, but they have to authorize it as a tax. They cannot do so through the guise of a regulatory scheme. Paying out an income tax refund is simply an indication that the government is raising revenue from one group and using it to spend on another, which is a classic indicator of taxation. That's not a regulatory scheme where you pay for the privilege of operating a bar in Jasper National Park.
Isn't that the difference, though, between this case and Connaught, is that in Connaught, it was essentially a user charge, a fee for the use of the privilege, and our case is not that. And why can't Parliament regulate behavior with a charge without saying, with a levy or whatever you want to call it, without using those revenues for the purposes of that scheme?
We're in agreement that they are two different types of regulatory charges. And in Connaught, the court describes how both of those purposes are permissible. A purpose of raising revenue to defray a regulatory scheme, or the purpose of affecting behavior. What the court declines to decide at paragraph 48 is whether in the case of a behavioral modification charge, which was not cannot, and which is the federal act here, whether that behavioral modification purpose means that the charge can raise funds to be used for general purposes.
So this is a point, I think you acknowledge, of first impression in this case.
That it has a behavior modification purpose?
Right.
Yes, we
Well,
agree
and-
with that.
And whether the requirement that the monies raised be used for the purposes of the regulatory scheme.
That is the question raised by this act, certainly. And we agree that there does not appear to be a case in which the Supreme Court has expressly ruled out that possibility. But conversely, our friends do not have a Supreme Court case which expressly says the opposite, that they are entitled to use those funds for general purposes.
So what then is the logic to saying that a charge for the purposes of behavior modification must be tied to the purposes of the regulatory?
Requiring that taxes be authorized by the legislature, requiring that governments don't impose taxes on each other pursuant to Section 125, limiting provinces to direct taxes only under Section 92, sub 2. All of these important restraints will lose their meaning if governments are allowed to fund their operations off behavioral modification charges.
And does our analysis start with the issue of what the pith and substance of this levy is, whether it's a tax or regulatory charge?
So the court uses the phrase pith and substance in Section 53 analysis, as well as in Section 91 analysis. But what it means by that in the context of Section 53 is something much more complicated than that. So in Connaught, the court goes through a fairly detailed test for what constitutes a valid regulatory charge, much of which is concerned with whether a scheme exists, which is not something that's disputed in this act. But it's not like the pith and substance exercise under Section 91, which just says, well, what is this really getting at? And that's where we classify it. It's instead something closer to a general presumption that a mandatory payment to the government to provide revenue is the default position is that that is a tax, and then there's a closed list of exceptions to that rule, one of which is that regulatory charges can be levied to fund a regulatory scheme, but that's not the same as using the money for general purposes. So if I could quickly take us to Allard, which we say, although not an express ruling on this point, is the best guidance that the Supreme Court has provided on this point. It's at tab 28 of the compendium. This was a case that dealt with provincial powers, but we say it addressed a very similar argument. At issue was a fee levied on gravel by municipalities, which was ultimately upheld as a traditional cost recovery regulatory charge, just like the fee in Connaught. But in the pages that we've excerpted, the court addresses an argument by 3 provincial attorneys general that where they act in a regulatory fashion, in their case pursuant to Section 92(9), they should be allowed to exceed cost recovery, which is the same argument that I've been addressing coming from Canada this afternoon. And in fact, it was an argument with some textual basis because Section 92 sub 9 says that revenue for provincial purposes. And even with that textual support, a unanimous Supreme Court rejected that argument. Of an interpretation for Section 92(9), which makes the licensing power clearly independent of other Section 92 heads. Then there's a citation for an article. In particular, it said that the power to raise money to support a regulatory scheme through indirect taxation already resides in the heads of power, as noted by Lafreniere, and that if licenses are limited in this respect, as in limited to cost recovery, Section 92(9) will be redundant. I am pressed, however, to mention that a power of indirect taxation in Section 92(9) extending substantially beyond regulatory costs could have the more serious consequence of rendering Section 92(2) meaningless. So if you take that analysis and apply it to the equivalent federal provisions, we say this federal act raises the exact same threat. If POG, or a new head of power recognized under POG, is interpreted as permitting raising revenue to be used for general purposes, like the provinces wanted to do with licensing revenue in this case, the ultimate result is that constitutional constraints on taxation are rendering meaningless. So we say cost recovery, that is the use of funds for something related to the regulatory scheme, is the constitutional requirement that should prevail in this area. And I won't take you to it, but the following tab has the article that the court is citing in the unfavorable sense of expressly rejecting the argument. That's an article by Professor Magnet over the next page. What the unanimous court is saying in Allard is that once we exceed the costs of operating a regulatory scheme, that is something that is simply not regulatory anymore and is more like taxation. And it will allow governments to circumvent the important limitations that we have on taxation. Admittedly, 92(2) is not a limitation that applies to the federal government, but Ontario says that Section 53 and Section 125 are equally important. I'd like to briefly go back to the example in Connaught I was discussing about cross-subsidies between national parks. The court held that if a profit generated by one park was used to operate another, that was the use of those funds for general purposes. Despite the fact that the federal government had an argument that there was one national park system under one statutory scheme, and that the funds were not being put into the Treasury for completely unconnected use. And we say that requirement is quite strict compared to how the funds are used in this scheme, which is essentially being provided to the population at large. And in particular, although Justice McPherson, you were discussing how Part 1 revenues are allocated, and we have legislation which tells us that, under the Act itself, and in the case of Part 2 especially, where there has been no such designation, the only requirement is that the Governor and Council designate that the funds be dispersed in the jurisdiction from which they arise. And it's not even a requirement in the Act that they be returned in the form of income tax refunds, of the form that applies in Ontario, because we know in those jurisdictions which voluntarily opt in to the Federal Act scheme, it's simply a check written directly to the provincial or territorial treasury. Because they have the flexibility to do that under the Act, because that's a way of being returned to the jurisdiction. So if a cross-subsidy between national parks, which share the same logo, the same minister, the same legislation, the same goals, if that was too much for the Supreme Court to be justified as a valid regulatory charge, Ontario says, how could this scheme, which simply sends checks, whether to persons or governments, for the most part, and where there's discretion for any number of uses of funds which have no connection at all to greenhouse gases, how can that be sufficient nexus? It seems like a much weaker link than that between Point Pelee National Park and Jasper National Park.
Just fill in this blank for me. The money raised starting on April 1st from the 4 cents a liter gas charge can be used in Ontario for what? What I hear you saying is cannot be used for Ontario people or Ontario institutions. So what can it be used for? Is it just?
Oh, I see. Not what can it be used for under the existing legislation, but under our theory of Section 53.
Under your theory.
Something related to the regulatory purpose of reducing greenhouse gas emissions. That is the regulatory purpose of the scheme.
Okay.
As the Council for Canada will take us through at great lengths under Section 91.
So money to emitting factories? Money to gas companies?
If it's to assist them in reducing their emissions,
Right.
that would be one theory of a link between the regulatory purpose and the use of the funds. So similarly, the cases that are cited in West Bank for a behavioral charge scheme deal with a beverage bottle deposit in Nova Scotia and a garbage fee in Ottawa Carleton. Now, in both of those schemes, there was no use of that money for general purposes, but that's an example of how the fee served a behavioral purpose by encouraging you to return your empties and to avoid creating garbage, but the funds were still used in a way that was consistent with that regulatory purpose, where there was a nexus. In the case of the beverage system in Nova Scotia, they funded the operations of an authority which engaged in waste reduction, and in the case of the garbage fee in Ottawa Carleton, they were used to create the waste facilities where waste was taken. So we have no objection to a behavioral purpose. We simply say that that does not allow an unlimited use of funds that it raises. That's not sufficient in itself.
Just to go back to my colleague's question.
Raise funds for regulatory purposes. Nothing to do with which is the superior way of using the money or what Parliament can or cannot do. It's simply that there's two tracks laid out by the Constitution. And when you use funds for purposes which are completely divorced from a regulatory purpose, you are picking the taxation track. And our Constitution requires that taxes be authorized by Parliament, which did not happen here.
I'm not quite sure that I understand your answer. It's maybe because I didn't phrase the question. In this case, if the purpose of the legislation, or one of the purposes of the legislation, is behavior modification, which seems arguable, why is it that the funds have to be used for the purpose of the legislation? I mean, isn't the legislation achieving its purpose through behavior modification?
It does achieve that purpose through behavior modification, but what the Supreme Court left open in Connaught was whether that is by itself sufficient to use the funds for something unrelated. So we agree that that's a totally permissible purpose for Section 53 purposes. The question is whether the government has no obligation to use those funds in a way that's related to the regulatory purpose.
But if to adopt your approach to the issue, it seems to me that would severely truncate the power of Parliament to enact behavior modification regulation. Constantly say the charge could only be applied for the purposes of the legislation.
The truncation is required by the principle of no taxation without representation. If what the government wants to do is raise money to be spent for general purposes, which again could be used to fund its entire operations, that has to be called a tax or something else very express and unambiguous. And where it declines to authorize a charge as a tax, it is subject to strict constitutional requirements as to the use of those funds, and we say that is what the Constitution requires.
But I just have one more question. Isn't giving the money back to the people of Ontario part of the regulatory scheme? Yeah. In other words, the more you spend on gasoline, et cetera, the more you pay. But we're not just taking the money away, we're going to give it back. And so isn't that part of the regulatory scheme? The recycling of the money back to the population?
No, because the Act itself doesn't require the income tax refund. So that is legislation that has been passed separately and which is deemed to be the use of the funds.
But the Act does say it must be paid back to either the province or the people.
No, the Act says that the Governor and Council may designate any class of person to receive the funds. So there's very wide discretion. It could be classes of persons who have engaged in designated greenhouse gas reduction activities, for example, is something that looks very different from how it's occurring now. There's the additional problem of jurisdictions that have voluntarily opted in, where the check goes to the Treasury. It's part of the scheme in the sense that it is in the same statute. Similarly to how the National Park Scheme in Connaught, there would have been the same argument there, that taking the money from Jasper and spending it in Point Pelee is contemplated by the scheme, is part of the regulatory scheme. It serves a general regulatory purpose of operating national parks, and the Supreme Court said that was not adequate, and we say the same is true here.
But just to follow up on maybe not understanding the scheme, I thought that Section 165(2) of the Act requires the minister to distribute the net amount to, to the province, to persons, etc. I thought that was in the Act.
Yes, just the additional, it's either persons, the province, or classes of persons designated by the Governor and Council.
That's part of the Act.
That is part of the Act. So Parliament has chosen to proceed for now that the Part 1 funds are designated through other legislation, but the Act on its face simply allows the Governor and Council to designate any
Within those categories.
I mean, classes of persons prescribed by regulation certainly gives a very broad scope to how it could be used. Just like most taxation statutes allow the government to use that money in a very broad sense.
I would have thought that part of the Act would be the only part of the Act that the Government of Ontario would stand up and cheer and applaud. That of all the things, money, starting with put it straight into the federal consolidated revenue fund so that it will be used only for federal purposes, to at the other end of the spectrum, lo and behold, give it back to the people of Ontario. I would have thought that would be the one, the absolute best recipient, Ontario would say.
Ontario cannot applaud where taxation has been imposed without the express approval of Parliament. Our argument doesn't turn on whether we approve of the use of the funds, whether we think it's prudent, or whether we think it is better than even worse alternatives. The legal question that we say this court has to answer is whether there's a nexus between the regulatory charge.
Just the questions my two colleagues down there have asked make it sound like it's really easy to come up with a nexus from this description. It's not hard at all. The nexus is and lo and behold, we're going to give it back to Ontario people. That strikes me as a pretty easy nexus.
So our friends have said the requirement to spend the money for regulatory purposes is an undue burden on Parliament's flexibility. What you have just laid out is how, in fact, there's many such schemes that it's easy to imagine how the funds can be used in relation to the scheme. If it's not that burdensome of a requirement, there's no reason that Parliament can't abide by it. And that's what Ontario is asking for here. Ultimately, giving everyone a check does not assist with climate change adaptation or mitigation, which is how the funds are used here. That may be preferable from a fiscal or policy view compared to some other use, but the purpose of the Act is greenhouse gas reduction. The requirement for a regulatory charge is that the funds be expended in some fashion with a nexus there. If it's not that hard to come up to think of schemes which comply, then there can be no objection from the federal government as to why they should have to comply with that requirement. Ontario will reserve the remainder of its time for reply.
Thank you. Ms. Tellis-Langdon, we finished a bit earlier than contemplated. You can certainly take some time now. If you'd like to start your submissions now, we could even take a 5-minute break to let you get set up. It's your call.
I'm at the school, so we have the whole day set aside for Canada's submissions tomorrow as well.
It's whatever you'd prefer. You got the same time. It's just a matter of whether you'd like to start now and take 15 minutes or so, or start tomorrow morning.
I think we'll start tomorrow for everything else.
Thank you. All right. Thank you very much. We'll rise until 10 o'clock tomorrow morning.